Yes. Serial number 33 and 34, my lords. Two weeks time may be given, my lords. I have some submissions to make in that month.
30,
My lords,
30.
33 and 34, my lords.
So what do you want?
My lords, time, I need some time, my lords. I have some submissions to make in that matter.
4th March.
Lordship, I move this. Lordship, I move this matter before the vacation ban. It is Lordship pleased to grant this matter, post it to this reopening, my lord. It is not yet posted, my lord.
What is the matter?
A matter for the consent for operation.
You listed it. You removed the office objection.
I remove the office objection.
You listed. Get it listed.
Please,
After a week.
please,
After 1 week.
please.
Serial number 63.
Give any data.
Serial number 24. 1
20?
week time. 24 serial number.
24.
1 week time.
Time. Why?
Time. 1 week time. Senior.
20.
Senior.
Senior is not there. On the ground that the 11th Senior Council who is to conduct the petition is not available for personal reasons, as requested, stand out, let it go then. 13th February.
Serial number 63, my lord. This is the domestic inquiry matter where for contempt we have filed an application. The
63.
same matter is being heard in as a regular appeal also. So we are withdrawing the, we have filed a contempt case. And the same matter, the opponent has come up and with a regular appeal, writ appeal, and that matter is being heard and the matter is going on. So we are withdrawing our, we are filing no press memo on that.
Serial number
Serial number 63, you've got.
63. 4/17/24. Governor Advocate Mr. Rudra Papi files memo dated 16/1/25. In which it is stated as in the quote the memo paragraph after quoting. In view of what is stated in memo, the petition is permitted to be withdrawn. The same stands dismissed as withdrawn.
That's okay.
Serial number
Lords,
71.
64, my lords. Serial number 64, my lords. 2 weeks time may be given, my lords. It's for office objections, will comply, my lords.
14th of February.
Much of this.
Serial number 71.
71.
Please, ma'am. 2 weeks time may be granted, my lords, for compliance of office objections.
71. 3 weeks time is granted for the purpose of complying with the office objections, failing which the petition shall stand automatically dismissed
Right.
without reference to or order of the court.
Please,
5th time,
my lords, previously
Serial
I had
number
done, but
78.
then I,
no problem.
please.
My lord, serial number 78, my lord. Pray for time, my lord.
78. No, let it be called out. PIL, lot of PIL is there. At the time it is called out, you remain present either physically or through video conferencing, we'll consider. Not now. Yes, yes.
My lord, pending contempt matter, this honorable court had directed for the matter to be listed today at 2:30.
Which one?
This regarding transfer of website, my lord.
Oh,
It
no,
was heard on 9th and for
not posted today,
it's not posted today.
Monday.
Very well. my lord. Just to appraise the court, my lord, the testing is not complete. Which is why permission of this honorable court is required to continue the testing of the website. The plaintiff, the petitioner was supposed to do the testing, which is not completed. And permission of this honorable court is required for testing because the commissioner and the defendant will otherwise.
So it may go to little later, 23rd.
No, my lord, they will not come forward for testing if this honorable court does not
That
permit.
Monday will see.
Very well. Obliged.
My lords, I'm for the complainant in this contempt, my lords. This is a fresh matter, my lords. In This is a fresh matter, my lords. In writ petition, it had directed the bank to hand over the key of the house to the owner, my lords. They have still not complied, my lords. Family or outside the house itself, my lord. They are not handed over the key, my lords.
23rd. 23rd.
23rd. Any other mention through VC, sir? And permission. Contempt matters. Seal number 1, Mr. Keshav Murthy B.
I appear for the complaint matter.
Seniority fixes.
On 5/9/2023, the learned single judge ordered the respondent to make necessary correction in the seniority list. Annexure A is the the order passed by the learned single judge. The relevant page is in page number 30, Miller. Para number 12. The respondent by pick and choose, they used to prepare the seniority list. Order to correct it. Even after giving a passing order, even after making repeated representation, the respondents have not bothered to rectify them. The petitioners are the employees of the BBMP.
You are petition number 1.
Yes, my lord. Many petitions are there, my lord.
No, you are which petitioner? Tushar,
As many as 10 complaints are there.
you are number 1. So you are appointed anyway.
Yes,
The
my lord.
directions in the order of learned single judge dated 15th September 23. While disposing of writ petition number 24317 of 21 are contained in paragraph 11 to 15, which inter alia requires the respondents to carry out necessary corrections in the seniority list by taking into consideration the date on which the petitioners were regularized. While the contempt is alleged in respect of the above directions, it is not possible for the court to conclude at this stage that any of the respondents have committed contempt of the court, much less a willful contempt, in view that learned single judge has not prescribed any time limit for carrying out the corrections in the seniority list paragraph. While not, therefore the present contempt petition is not entertained. Paragraph. At the same time, the directions of the court should not go uncomplied with. Therefore, it is directed that the respondents, competent authority respondents shall take necessary steps to comply with the directions of the court in the aforementioned order of learned single within 8 weeks from today. Within 8 weeks from the date of receipt of 31st of this order. Yes. The contempt petition is accordingly disposed. It will be open for the counsel for the petitions to furnish copy of this petition along with the copy of the order to the counsels
Yes,
who
ma'am.
normally appear before this court on behalf of respondent number 1 and respondent 2. Right?
This number 2. Archana Murthy.
Appearing for the complainant matters.
Yes,
Filed our affidavit,
I'll affidavit.
please.
Can satisfied with whatever stated in the affidavit. So this is time bar. Yes, what yours?
My lords, we have filed our affidavit, my lords, endorsement has been issued.
Full stop. The contempt petition does not survive since, for the affidavit, where is the affidavit?
Lords, it is at page 7 of the affidavit, my lords, is the endorsement, translated copy. It is dated 28/2024.
Please select one. Governor additional government advocate, Srimati Pramodini Kishan, invites attention of the court to the compliance affidavit along with which endorsement dated 20th/8/24 is produced, to further submit that the issuance of said endorsement of lip holder amounts to compliance of the directions of law and a single judge. Paragraph. Learned advocate for the petitioner, Ms. So and so is not in position to dispute the factum of issuance of order of endorsement. Paragraph. The contempt petition is not, will not survive. Accordingly, it is disposed of. It is however clarified, paragraph, that
My
if
lords,
the petitioner is aggrieved by the endorsement of lip holder, it will be permissible for the petitioner to institute independent, appropriate independent proceedings to challenge the same. In respect of merits of which this court does not express any opinion.
Serial number 3.
Opening with the complainant, Lordship. The
Lords, we have filed our affidavit here also, my lords. We have filed, my lords, and it is at page 20, my lords, dated 18/3/2020.
What are the?
Annexure, paragraph 7 of the compliance affidavit, my lords, on page 5.
These are held and top in the land petition.
Annexure R6 also may be kindly seen, page 29, which is again a second endorsement, detailed endorsement. It is dated 31/8/2024 months.
So what is the reason for not felling the trees?
Not
they have-
felling
They
the-
have again passed an opinion on this honorable court's order
Hmm.
where it was thoroughly heard. In fact, one of the objections raised by the registry here, why was accused number 3 made a party? The accused number 2 has passed this order based on the opinion of the accused number 3, who was also a party to the writ petition. They have passed an opinion in this honorable court's order where this was discussed thoroughly that I have a right to cut the tree. Again, they pass an opinion in contempt of this honorable court's orders, Lordship. This is in page 46. The honorable court had clearly said that, if I may read, Your Lordship.
So you want to uproot certain trees?
Lordship, this matter is simple. I am a senior citizen. I am a farmer having coffee plantation. The tree cover, which is exceeding certain limit, hampers the growth of coffee. So I had to trim and cut certain trees. Whatever trees I'm going to cut and everything I submitted before the court, I will cut it under their guidance, despite which was considered by this honorable court giving directions. They again pass an opinion, you can't cut it.
Lords,
It is just to
only
cut. My
submit-
plantation is going to be plundered. Now is the season for me to cut it, so because the
My lords,
coffee season has started now and I'll be suffering a lot of loss. This is my sole source of income.
as per my instruction, my lords, other trees permission have been given, like silver oak, mahogany. Lords, this is a permission for rosewood, my lords. That, my lords, it's a property belonging to the state. Therefore, an endorsement
I
has
will
been,
cut it and give it
rightly
to
or wrongly, an endorsement has been issued, my lords. They have the remedy to challenge it. This is my respectful submission, my lords.
Lordship, in fact, their own affidavit in page 32, they clearly said, I may read that paragraph. In their affidavit, the government advocate issued opinion stating it's a fit case to file appeal against a judgment order dated so-and-so. But legal cell of forest department decided not to file an appeal. The entire matter has been heard.
Page 9 is the endorsement with their affidavit.
Lordship,
Permission to cut trees as per the order.
yes,
Yes, same.
yes, Lord.
So what does it say? For rosewood trees.
Yes, Lordship.
Rosewood.
And I had submitted before the honorable court, it will be under their supervision. and it will be given to the depot in the government forest department. It is not that I am taking it. Whatever is cut will be deposited with them, despite which they are performing an opinion. If it's not cut, it affects my plantation. It's not that I had planted it.
My lords, may kindly see last paragraph on page 34.
What is war grant saga?
Lordship, my father was an ex-serviceman and it was granted to him.
War.
Yes, Lordship. In fact, Lordship, may kindly see the honorable court here. It was clearly mentioned. The first condition on the land granted may be free of land and timber value, though the said condition is not happily worded. In page 6 of my petition, para 4, it clearly, the order clearly says it's not happily worded. What would unmistakably emerge by reading the entire document? That the land or timber would not be sold. This would not mean that the petitioner is not entitled to fell or cut trees. There's a clear observation made by this honorable court. Despite which they had the opportunity to object to it, they appeared, they were heard at length, and now again they form an opinion on an order passed by this honorable court. The cutting can be done in their observation only, Lordship. It's not that I'm going to take it and sell it. I'm going to give it in the same forest department back.
The petition was filed by the petitioner complainant seeking communication of the Deputy Conservator Forest, Virajpet Division, Virajpet, Kodagu District, whereby the petition was denied the request to fell or uproot certain trees in his coffee plantation. It was the case of the petitioner that trees were required to be cut and fell to protect the grown-up plants or to facilitate the growing of the coffee plants. Learn a single judge paragraph by his judgment in order dated 13 January 23. Directed respondent to Deputy Conservator Forest to consider the representation of petitioner in accordance with law. Post of the said direction preceded with the observation that the jurisdictional tree officer shall oversee the trees that are being felled or chopped in the land of the petitioner. It is further observed that the petitioner shall also undertake to plant such number of trees which are uprooted for protection of his plantation on the borders of the granted land. The grievance in this contempt petition is that while the authorities permitted certain trees to be held, comma, cutting of rosewood and other trees standing in survey number 2/5 of the Badaga, Banangala village, Virajpet Taluka, which is the land in question on which the trees stand, are not permitted. In response to the present contempt petition from an endorsement dated 3/4/24, 8/4/24, 3/4/24 is produced on record, whereby in which it is inter-alia stated that the cutting of rosewood and other trees on the land in question would not be permitted inasmuch as the ownership of the land and the trees, as per the order of the Deputy Commissioner from a war grant land, was not redeemed, and that the applicant is not having any right over the trees. With such observations and reasoning, the permission to cut certain trees, including rosewood trees, have been denied. Paragraph. As the representation of the petitioner is considered, paragraph, and the endorsement as above is issued, it would not be possible to conclude that merely because the cutting of the trees is denied, it amounts to committing contempt of the court. Full stop. The contempt petition will not survive as the endorsement is issued. Paragraph. However, it is observed and clarified that if the petitioner has any grievance about the merits of the endorsement of the order, it will be permissible for the petitioner to institute appropriate independent proceedings to challenge the same, in respect of merit of which, however, this court does not express any opinion. The contempt petition is accordingly disposed, has not survived. Yes.
Seal number 4, Mr. Keshav Murthy.
I appear for the complaint, my lord. On the last date of hearing, they have issued an endorsement.
The endorsement.
They have issued the endorsement, my lord.
It was remanded.
Lords, this is with respect to outsourcing of employees, my lords. The direction was the state government to take a decision. State government has taken a decision and communicated to the Mysore City Corporation, which is at annexure R1, page 5, my lords. Translated copy is on page 8, my lords. And thereafter, page 14, the Mysore City Corporation has issued endorsement to the complainants, my lord, because Mysore City Corporation is the competent authority.
Page 40.
Page 14.
Mangaluru City.
Lords,
Or Mangaluru.
Mysore City Corporation,
Mysore.
Mangalore.
Mangalore City Corp, sorry.
So nothing survived. What was directed by a single judge in his order dated 7th August 23 while disposing of the and was to decide to take that the state government shall take decision afresh upon remand of the case by the court after setting aside endorsement dated 18th March 2019. Paragraph. The fresh decision is taken. Paragraph. As pointed out by learned additional government advocate Srimati Namodini Kishan, inviting attention, who invited attention of the court to the compliance affidavit. Also, the compliant affidavits accompanies endorsement dated communication dated 12/9/24 the Urban Development Department of the government to the Commissioner, Mangaluru City Corporation, and the consequential endorsement dated 12/9/24 passed by the, issued by the Bengaluru City Corporation, whereby the prayer of the petitioner for equal pay for equal work is declined. The above decision marks compliance of the directions of law and assembly as the decision aforesaid is taken. The contempt petition does not survive this disposal. The comes to if the petitioner has any grievance about the decision taken, come on, will be permissible for the petitioner. Institute appropriate independent proceedings to challenge the same.
Yes.
In accordance with law. However, in respect of which this court does not express any opinion. The contempt petition is accordingly so is not surviving.
Seal number 5.
I'm the complainant in this case, Madam. Honorable Writ Court has directed the accuser to consider representation of the petitioner within a period of 3 months, my lord. Thereafter,
So-
the
Madam, what is to be done? Notice? Notice, you are not.
Lords, I'm not party in this.
BD, my lord.
Is returnable on 4th of March.
Grateful.
Seal number 6. H. Maltesh.
Application, my lord, to, for Podi and Durasti.
There is no time limit to save. Anybody appears?
I appear. There's no time. And also, there is no time limit prescribed, my lords, and also they have not made the
That
parties.
doesn't mean that
My lords,
you are not a party.
my lords, we have made a party, but the necessary parties have not been. What they have made in writ petition here in contempt, they have not made. Like Tashildar, my lords, who is the necessary party, and the project direct officer under whom the land falls under, he is not been made. Necessary parties are
At
not.
the outset, learned advocate, Mr. So-and-so, request the court to permit Tahsildar, which thereof
Mysore
Mysore Tashildar,
Mysore
Mysore
Taluka.
Taluk.
as party respondent, inasmuch as the directions sought to be complied with, will have to be complied with by the Tahsildar. Permission is granted, the Tahsildar Mysore Taluka shall be impleaded as party respondent by way of carrying out an amendment to be done within 3 days. Paragraph. The direction is direction of law and single judge.
Assistant Director of Land Records also is a necessary.
My lords, instead of assistant director, my lords, Srimati, so-and-so project officer, UPO or office is the necessary party, my lords, I have ascertained.
Then you file again. You are not impleading proper part.
Lord, direction given to, my lord, the respond number 5. Direction, my lord, given to, my lord, respond number 5.
Deputy Director, huh? So he's not a
Deputy
party.
Director of Land Records, my lord.
Deputy Director is also not, it is a party.
Lords, since
The land,
this is a,
Deputy Director of Land Records, my lord, I made a party as respond number 1.
Why
since
should we?
this is, my lords, may I make
Should
one?
we implead Tahsildar?
My lord,
Yes.
since this is a grant land, my lords, the first grant records have to be put into, that can be done only by the revenue department, that is the Tashildar.
So this number
Unless that 1
number
to 5 is,
Only, my lord, I am seeking the direction for
5
the
is not
Podi.
revenue authority.
my lord,
Number 5 is also revenue authority.
no, my lords, 3, my lord, in the writ petition Tashildar.
So same for you, Tahsildar arrange within 3 weeks.
Please,
Paragraph.
please.
The direction of law and single judge is in respect of conducting of body and jurisdiction in respect of the subject matter land as provided for in order dated 19th December 23, brought under contempt. Paragraph. The directions as is clear from the bare reading does not contain any time limit for compliance. Therefore, at present, it cannot be said that any of the respondents, including newly added respondent, has
No, I am seeking, my lord, my one more.
court. However, at the same time, the directions of the court should not go uncomplied with. Therefore, by requiring responsible 6 Tahsildar. Right? Which order you are?
My lord, Annexure A, my lord. Annexure B, my lord, is 2014, my lord, order.
Kelly? What did you write? to carry out the directions of conducting body and duress in respect of subject and within 8 weeks from date of receipt of certified copy of this order, the present contempt petition is disposed of. Not entertained.
Let's,
as
this writ petition only, there's direction to consider their application.
At present.
Their direction is only to consider the representation, their application.
All legs, not conducting the body and duress, consider the application for
Please.
conducting the. Little longer time you need.
Let's, time
12
frame,
weeks.
3 months time,
3 months.
please.
Number 7, to KV Narasimhan.
For complainant, my lord. For considering the application for conducting the rest and body.
Notice written ever on 6th of March.
Obliged. Obliged.
Number 8, to Arvind N.
Appearing for complainant, my lord. Notice has to go to accused number 1 and 2 minutes. Let's. The single judge has ordered to change the revenue records as per the compromise decree in OS suit, my lords, which is direction is at page number 16, my lords.
This
16 and
successfully completed
17.
Immediately. Notice written
Yes, my lord. For accused number 1 and 2 both.
6th of March.
Much obliged.
Number 9. to
For
Vaishali
complainants,
N.
my lords. My lords, accused has not complied with the directions issued by learned single judge to conduct body and duress, my lords. It's been 1 year for the order, my lord. We have given several representations. Till today, it has not been done, my lords.
Notice 6th of.
Obliged.
Number 10. to Sumana Naganam.
Now this does not survive, in fact, kept for order.
Please, Miller, just one.
College already shifted.
Please, Miller, just one to place on record. There's been an amended rules. Last time government made just for your lordship's consideration is to place it on record, but that requirement is still there, even in the amended.
What require?
Minimum area requirement. Minimum area requirement for colleges to run, to get permission.
My lord, the very cause of action is not there, my lord.
Once.
Yes, the college has shifted.
Some prayers are
Yes.
added.
No, the prayer is only against respondent number 5.
My lord, that's not
But
correct. We have amended it. That is not, we have amended the petition.
What
My lords may kindly consider that, but it's not infructuous because we have asked for other.
The noting is that for orders.
Please.
Anyway, we.
Please.
The
Respondent number 5, it has been redressed.
Your prayer.
But,
Prayer is about the construction of the college at Aswini Colony, Vijayanagar.
That has been redressed, but the amended prayers.
College already shifted to.
That has
different
shifted.
place. This prayer does not survive. All other prayers does not survive, except you are seeking some amended prayer at page 42.
Prayer
Wanting any
40.
extension of time to pre-renew the colleges, to adhere with rules. So it is too general. No, non-specific prayer.
No, my lords, I
No
didn't.
cause of action arisen for this prayer.
No, my lords,
My lord, only prayer is prayer 5 and 6.
no, my lords,
5 and 6. 5 and 6.
no, my
The
lord.
cause of these proceedings, grant such other reliefs.
No.
For a relief, there should be a cause of action, I can understand.
No, my lords, just to this honorable court asked us to implead, my lords. That's the only reason to bring the context. I leave it to my lords. Beyond.
Writ petition number 38010. How many are? 5. 5.
Well, it's appearing for respondent number 5 minutes.
5 is present.
How many petitions are there? 5?
No, my lord, petitioners are.
Petitioners are
So why
6,
this
my lord.
one?
Petitioners are 6.
38010 of 2009. Heard learned advocate Mr. So-and-so, petitioner and learned additional government advocate Srimati Neelofar Akbar for the respondent state and its authority. The present petition was filed as back as in the year 2009, styling it as public interest petition. The grievance sought to be advanced by the petitioners. Was that this one number 5 society. This one 5 Chaugle Education Society, which was running an educational institution in the name of Vidyaniketan Pre-University College at Diamond Corner, Deshpande Nagar, Hubli. Was involved in setting up a new pre-university college to the allegation that the setting up of the college was without adhering to the norms of the construction and the approval of plan. It was stated that the deputy director of this Punatu Hubli Dharwad Municipal Corporation had received letter stating that the sanction plan for construction of the pre-university college in the proposed site was not approved. With such main application elaborated in the pleadings of the petition, the various prayers were made. The first prayer paragraph was to set aside the permission granted by Respondent 2 in favor of Respondent 5 for construction of the pre-university college. The next prayer was to set aside the sanctioned plan approved by Respondent 2 in favor of Respondent 5 for construction of college. The third prayer was made to declare that the inspection report issued by Respondent 3 and 4 was illegal and contrary to the rules. The permission granted by Respondent 1 in favor of Respondent 5 for establishing its pre-university college was sought to be closed, was sought to be set aside, was sought to be set aside. Paragraph. During the compliance affidavit. This many. Yeah. In course of the, while the petition remained pending, paragraph. For a long time, compliance affidavit dated 3/1/2025 came to be filed. not compliance. Affidavit dated 3/1/25 came to be filed by on behalf of the state of Karnataka, in which it is stated that the relief prayed for in the petition did not survive, in view that this 105 has shifted the pre-university college from Ashwini Colony, Vidyanagar, Hubli Dharwad district to another place called Yan Siri campus, Biri BIRI, Biri Devara, BIRI DEVA, Biri Devara Poppa, Hubli Dharwad district on 1/4/2023. It is further stated that the new institution proposed will be situated in the area of about 5 acres and building measuring 60,000 square feet, housing classrooms and office premises to be constructed at such new place. It was further stated that report of the spot inspection was submitted, and since the reports that indicated the violation of the rules, a show cause notice was received to this file on 21/6/2011. Thereafter, the development took place whereby the setting up of the college, pre-university college, was shifted to different place. In view of above development, the above factum is the above factum is an admitted aspect. The petitioner could not dispute the fact that this 105 has dropped the earlier proposal of setting up the college at the place complained of, and the college is now shifted elsewhere. The public interest petition, therefore, will necessarily will not survive. Learned advocate,
With regard to the other colleges, the other,
the petitioner invited attention to the court that the petition was amended and following further prayers were added in the petition. Which prayers, according to the counsel for the petitioner, would survive for consideration? This page 42, red bracket. Full stop. It is not possible to countenance submission of the petition. That court should consider the aforesaid prayers for the simple reason that the prayers are too general and too vague to be adverted to. Not only that, the prayers are not based any cause of action. Full stop. The directions as generally and vaguely pleaded cannot be granted. In eye of law, the prayers of such nature and kind could be said to be misconceived. Therefore, those prayers are rejected. Full stop. The public interest petition is disposed of as not surviving.
grateful.
Disposed of as dismissed. Public interest. In the above view, the public interest. In the above view, the petition is dismissed. All interlocutory of applications will not survive any of the disposal of main petition.
Applications. System number 11.
My lords, I appear for respondent 11 in this matter. I think on
Your
the-
Lordship, I appear for petitioner.
I think on the last date, my lord's report was to be filed by BDMP and an affidavit Further,
BMP is there.
further affidavit was to
Yes,
be
my lord,
filed.
I appear for the respondent number 2, my lords. The last date we have filed an affidavit, my lords. In the last date, we have filed an affidavit.
Filed everything.
We have filed it.
I think petitioner had asked some time to just respond to that or wanted that affidavit perhaps.
You are for?
I'm for respondent Levin, I'm a private.
I appear for petitioner, your lordship. We request for some time to respond to that affidavit, your lordship.
Your affidavit is dated
22/11/24.
20.
22/11/24.
Listen. You are for whom?
Appear for the R5, my lord. KPT.
Who is there?
KPTCL. KPTCL, my lord.
KPT. How the KPTCL is concerned?
My lord, the work is done, my lord. So
You are
they have
doing the
completed, yes. my lord.
Road work you are doing. Digging work.
Looking for the lines to be, all the agencies were asked to be brought in, my lord.
That's it. Road is not the dig road. The new road is what?
Who appears for BBMP?
Here for BTMP.
See, you are doing this white topping of the road. Probably you'll have to answer how far it is scientifically proper to do this white topping. Because there are many reports which say that it's not advisable. The plain tar road makes much more sense for water seepage, for everything for that matter.
Yes, my lords. We'll make a reply on it on the next date, my lords.
You are doing this repair work of pothole periodically or whenever monsoon comes?
My lords, in the affidavit, we have
Not stated anything about that. Is it a periodical mechanism evolved by you or only when the monsoon comes or some PIL is filed? When you travel in your car on the road and potholes comes, you will not be smiling. Like smiling here. Or let we grant time to the, but we'll dispose of with some direction. Yes, who is for petitioner? Left, as if time is granted. Third of, not third of, but 20th. February. This follow from 20th. Old matter.
ఇక్కడ
Seal number 12.
For the petitioner lordship.
I appear for the petitioner in 12.2.
Yes.
Which is a
12th December order, your lordship.
directed against illegal advertisements in the name of PPP.
Now that,
My lord, as per your directions, my lord, we have.
now that Lexis matter is
The same, my lord.
Same matter.
Same.
This
the
is the
same matter.
This is the matter, man. On the
that-
last occasion, my lord had directed, saying that the penal provisions.
Where is the last, that CO motu petition, same is including?
Suo motu.
Oh, that is kept for orders or it is disposed of? I am not recollecting.
40.
No, the direction was issued.
12.3.
What is clubbed with this?
12.3.
It is clubbed with this.
12.3.
Yes.
No, my lord. 12.4 is the suo motu.
12.4 is two.
Now PPP advertisers are advertising without any prior permission and without paying any tax. And therefore, we have preferred a writ petition before this honorable court, seeking direction against PPP advertisers to prosecute them for not taking permission before advertising and not paying tax in respect to the advertisement they have put up. Some of the petitioners are also hand in glove. They do not complain against it. And the PPP companies have been enjoying a free run without paying any taxes and without taking prior permission, as it is a mandatory requirement.
This disfigurement act will be segregated from the taxes because two are not exactly same.
Segregate ಮಾಡ್ತಾರೆ ಅಂತ ಹೈಕೋರ್ಟ್
So for implementation of the Karnataka Open Places Prevention of Disfigurement.
Yes. I have demanded it.
That petition deserves to be segregated from the Plexis matter.
Yes.
Because Plexis illegal holdings are little different.
In this matter, my lord, we are representing for impleading applicants.
Pardon?
Impleading applicants. We filed
Impleading, we'll see, all are impleading.
Lord, the only, as per bylaw is, my lord, 12.3 of the BBMP outdoor signages and public message bylaws 2018. There is a clause, my lord, is saved with regard to PPP projects, my lord. 12.3 clause bylaw. In
Your
12.
lordship, 22/10/2024 order, the main matter,
Yes.
they were required to submit the bylaw, which has been, now they have submitted the bylaw. Now, as your lordship observed on 12th December 2024,
Correct.
there is no penal clause in the area because if it is illegal. So in that regard, they have to modify that bylaw specifically, 12th December, your lordship.
My lord, as against compliance, as against that order, my lord, it is already complied, my lord, and we have already filed the complied new bylaw also with my lord, on 13th January.
The court observed that in your
Yes,
bylaw,
yes, my lord, yes, my lord.
there is no penal.
We have done that, my lord. We have carried out and the government has also approved that new one. We have included it. Yes, my lord. we have
Well, it's not.
Copy is not
New copy
supplied.
quotation, new hard copy. New market. Marketing.
May I request the court to kindly direct the implementation of that bylaw immediately, because hundreds of crores of rupees is lost to BPM.
Page 32, my lord, may I request? Page 32, my lord. Lord, page 15(3), my Lord. 32, my Lord. 3(2), my Lord.
32.
Lord, 15, my Lord. 15(3).
Is not on the first. 15(3) is apart from the removal.
In case of illegal or unauthorized. Lord, I think the old.
It is an
My Lord,
amended.
in the affidavit dated 13th, my Lord, January, 13th January.
13 January.
Obliged.
That copy is not served to all the other.
You are right.
So there is.
My Lord, this is pertaining to Bangalore, my
There
Lord.
is no copy. Copy is there. You if not served the other side, then I will proceed. January, 15 January.
On 13th
13 January.
January, my Lord, I have filed in compliance with my Lord's.
So these are the fresh bylaws.
Yeah,
Amended.
amended. Page 32 in that.
Page
32, 15(3), my Lord.
In case of, yes.
15(3), may I read that portion, my Lord? In case of illegal, authorized, unauthorized advertisement or displays on flexes or banners apart from being removed or demolished, both the persons responsible for erecting the same and the persons on whose private property such illegal or unauthorized advertisements or displays or flexes or banners have been erected shall be liable for criminal action under the applicable laws, including under the Karnataka Open Place Prevention of Defamation Act, so and so. And the next one, my Lord, apart from the removal of or demolition in the case of private lands or properties, the owner of the property or land where infrastructure for unauthorized advertisement was created or unauthorized advertisement was disclosed is liable to pay penalty at the rate that is twice the rate fixed in auction tender for the said road or circle. This was added, my Lord, in
Same copy. Copy. Last time copy.
Actually, BBMP is shielding the illegal holdings by the PPP companies. They are not insisting on taking prior permission, which is a mandatory requirement.
If the penalty is not paid, then what?
My Lord,
The penal consequence.
penalty clause is there. my Lord. It is there.
The penalty is not paid by the defaulter, then
My Lord, in the
recover penalty.
land revenue, my Lord, we'll have to collect it
That is not there. There's areas of land
in
revenue.
accordance with law.
By attachment of property.
As per the act, my Lord, we'll have to collect it as per the act in the provisions of the.
Act may have provision.
Yes, ma'am.
That is.
BBMP Act.
Actually, BBMP Act 2020 does not provide for, that's what I submitted last hearing day. It does not provide for any criminal penal action, only penalty. That's all the law says in the advertisement law. On that bylaw only it is a continuing one, but nowhere, because they are only referring to the Kannada Open Places Prevention of. That is a separate enactment, which is in 84 to prevent all abuse. Now the 220 Act, 2020 BBMP Act came into force. In that, there is no such provision to. So if any person challenges, this bylaw will go. Basically, this clause 15 will go. That's what I submitted last hearing.
My Lord, may I request, page 33, my 33. Provided that the BBMP reserves the right to recover the above dues
for the unauthorized advertisement from the advertising issued instead of the owner.
That's correct.
And as against the owner of the property, it will be recovered.
Mechanism of
The model,
recovery is not controlled.
how it would be recovered.
326. 1 year.
This advertiser, not the owner. They are recovering.
No, whether from advertiser or.
The owner, if owner defaults, because owner is being allowed to put up such advertisement.
So this we are keeping for orders, as far as this suo motu petition is concerned.
In fact, in matter pertaining to solid waste management, when KMC Act was enforced, this Supreme Court specifically pointed out where is the penal provision, that is criminal action to be. Then that section was amended. But now while introducing new act, there is no such section at all, Your Honor. KMC Act, it is there, still there.
In
It doesn't.
bylaws, they have come out with some.
Yes.
provision. And we'll say that this is the lacuna of mechanism to recover the penalty. You may edit or our order will operate.
Now, what I respectfully submit is,
In 326 finally, madam.
Then page 10.
326 of BBMP Act.
Your affidavits are filed in this old matter. That's it.
My lord, may I request, my lord, which my lord was now. Page 18 of that, which my lord wanted to know, my lord, page 18, my lord. The third paragraph.
18, yes.
18, my lord, of the affidavit which my lord just. Third one, my lord, any arrears or unpaid demands of advertisement from either a licensee advertiser or anyone who is liable to pay the advertisement fee or penalty or interest, if it remains unpaid despite becoming due, shall be recovered in the manner prescribed for recovery of demands for arrears of property tax. Yes, it is done.
It is there. So that is enough.
Obliged.
You are. What about this 57990
that has become infructuous.
Pardon?
That has become infructuous, 17 met, because subsequently there is a change in the bylaws and
57990 will become infructuous.
infructuous.
It goes with that only.
Same.
Same.
5798.
So how many matters are involved here? 3.
I appear in 12.2,
5.
2044.
All are saying 4, flex, illegal flex.
Except the, which my lord, my suo moto case, my lord, that is separate.
12
Suo moto is separate, which my lord,
Subject matter is same.
subject matter is same, my lord.
So it can be.
There is a hoarding, my lord.
So all can be disposed of together.
Here.
No, 12.12,
No, my lord.
12.2.
12.3 is with regard to the LED, not the flex. LED is entirely different from this, and there is a opinion from this honorable court. It has to be de-tagged and it has to be heard separately.
Which one?
12.3, my lord.
12.3.
3. Your lordship, I have filed a one IA for direction also.
Another aspect, your lordship.
So also 12.2, 12.2 needs to be separated because it relates to the mandatory requirement of taking prior permission and
So
payment of tax.
12.3.
Yes.
12.2.
12.2 also.
12.2 may be separated.
No, but that is also pertaining to, my lord, may I request?
So give the appearance of all the matters except 12.2 and 12.3.
12.1, my lord. Now your lordship is dealing with the only BBMP here. Your lordship can see the order in earlier petition also, your lordship is also stated.
Will not.
It has to be gone to entire Karnataka state. Now we are dealing with only Karnataka. My petition is to entire state.
That will.
Because your lordship may kindly see the order passed by the honorable court on 22/11/2019. We look into the matter subsequently and that was indicated.
So we'll dispose of 57990.
In that, my lord, I filed impleading application formally,
Then
my lord, only
One
to.
1 second. Impleading now doesn't, sir. Then 5703.
5703, it has to be applied to the entire Karnataka.
We'll consider dispose of along with this. We'll consider how to deal with it. And 12.4 also. That is the CO mode. So all these 3 matters give appearance and resort for orders. Appearance.
Your lordship may
I'll
kindly
just
see,
dictate, don't write.
kindly see the order dated 22/11/2019, wherein the honorable court has stated it has to be applied to the entire state.
We'll consider.
And one submission, lordship. On 22/10/2024, this court directed is notwithstanding the bylaw to be approved. We are free to produce the document material so that any unauthorized illegal thing. So the memo has been filed on 15 January to show that several things been put up now hoardings.
If you want to give something in writing by synopsis, give within 4 or 5 days.
Yes, sir.
Any of the parties.
Yes, sir.
And you can,
Yes,
by summarizing.
Public. Because there is already an order on 2nd August 2023,
Help us.
50,000 penalty, your lordship. Already this court has observed 50,000 each by BBMP and by the state
Whatever you
government.
want to
That
say,
is-
you do it
yes.
as synopsis. You also.
My lord, yesterday what
That
he
is
is
only-
saying, Mr.
This is 12.3, my lord. I have filed one IA for direction. In
That
the-
we are putting up on some separate.
Separate.
Separate day, any day, earlier date, make it 12.2.
12.2 and 12.3 will go together.
No, they are separate.
They are separate.
They are.
Subject matter
So
separate.
12.2, 204422, it shall stand over to 20 on 30th January. And
Please.
12.3, 4083 shall stand over to 6th February.
Methods in 12.3 methods, sir. Let's see. 12.3 methods, I hear that an application has been filed for some direction. Let him serve a copy upon us so that if we have any
They have
objection,
served. They have served. Now also I am ready to serve the copy.
let them give us
Here
another
the
copy.
fact is
So in
that
both while the petition shall stand over to such and such date, the parties may complete the pleadings
Please,
if
methods.
so required.
If so required,
By
yes.
exchanging them,
Grateful, methods.
exchanging them
One submission, lord.
Even on 12/20.
for the next date.
12/8/2024, your lordship has ordered. It will be
Will you dispose of, for reserved for order?
dealt with in respect of all other.
Will appropriately deal with.
12.3.
Essentially the same, but for entire state.
Entire state.
To segregate the.
Well, that's 12.3, my lords, second week of Feb, my lords.
Which one?
6-2.
Mine, in my matter.
Lordship, the main issue which we raise, my person called a new council has come. See, these banners, after they put up, they will remove it. And it will be thrown to the stormwater drains. And then it causes the pollution, it goes to the lakes. That is the main issue. And earlier, Mr. Joshi was appearing in this matter.
When will hear, we consider.
Because they have to examine that also pollution control board. The learned friend has to look into that aspect.
Therefore, we are.
Because basic thing for filing his petition is only that cause.
Therefore, we are segregating.
My lord, one submission, my lord. The new bylaw, your lordship may permit us to notify. My lord.
Now we wait for 15.
Yes, ma'am. Yes,
3
please.
weeks, so within 2 weeks.
We'll wait.
Deliver the judgment and.
Yes, oblige, ma'am. Oblige.
We'll give priority in this matter.
Oblige.
IA may kindly dispose accordingly. Impleading application may kindly dispose.
It is disposable. Yes, next.
So, number 13, Mr. Shyam Kumar issue.
What is it? Reason?
Present matter, my lord, on 13/11/2024, my lord had directed the petitioners to implead, my lord, the union government, and they wanted to produce some report.
Seeking time, my lords.
At the request on behalf of the petitioner, stand over to go March on now, in March, 17th March. You're not really serious in proceeding.
My lord, senior counsel is not available.
Anyway. March 17th.
Please.
In the meanwhile, the newly impleaded respondent shall be solved by the petition.
So number 14, writ appeal matters.
I appear for the petitioners. This is the petition, my lord. Descom has filed this.
Delay.
178 days delay, my lord. Immediately after passing the single judge order, my lord, he has referred the matter to the legal opinion, for it is the fit case for appeal or not. After obtaining the legal opinion, my lord, legal experts, he was sent to the department, and hence, my lord, 178 days delay. There is an affidavit was filed in this regard in ink page number, my lord.
So IA number 1 of 24.
17.
All are solved.
No. Now appear for respondent number 1, my lord. There are private respondents here.
Yes, ma'am.
Private respondents from 2 to 7, my lord.
This is the electrocution, my lord.
Notice returnable on
2 to 7.
My lord.
12th March. There is a fresh matter.
Yes, ma'am. Electrification matter, my lord. It is the stay was we have received on the ground that, my lord, the Supreme Court, the Supreme Court. Yes.
Until delay is condoned, the appeal cannot be considered.
Yes.
Notice.
Because. Yes.
We'll give early date.
Sure, ma'am.
Returnable on 24th of February.
Much obliged.
This is number 15.
Lords, pursuant to filing of the writ appeal, there have been certain subsequent developments, my lords, because of which the writ appeal may not survive. We've sought instructions from the client, my lords. I seek 2 days,
Repatriation.
my lords.
Repatriation has been.
My lords, to place on record whether the client wants to withdraw the appeal.
2 weeks.
Two.
At the request on behalf of learned the appellant, who wants to take Miss so-and-so, who wants to take. You are Sumana Naganan.
Please, my lord.
Sumana Naganan wants to take instructions, stand over to, we want 2 weeks. So 30th January to be listed at 2:30.
Obliged.
So number 16, Mr. SB Mukanappa.
The appellant is not. And my lord, the matter pertaining to my lord that the promotion.
What is wrong in this?
And my grievance is only this, my lord. The fact that the seniority is concerned, my lord, there is no, I have also annexure F, my lord, your lordship may kindly see page typed copy. Page 82, my lords. Serial number 1 and 2, my lord, are not eligible to be promoted because one is, my lord, having the facing the disciplinary inquiry. Second one, the first one is having other disabilities. The learner said dismiss my application only on the ground that, my lord, I questioned it at the belated stage. The appointment of the, my lord, that the third respondent itself is, my lord, is not correct. It is quite contrary to the recruitment notification.
This Basappa was promoted when 11 years back.
Yes.
Ah.
Yes, the third respondent, the another one, my lord, that this first respondent, the first one, my lord, serial number C, now he is facing disciplinary inquiry. He is not eligible. The second one, the appointment itself is bad, my lord, because he is not having the requisite qualification in terms of the recruitment notification. Now I am at serial number 3. These two persons, they are considered as zonal level. These two names has been sponsored. I also produced annexure D. The judge, my lord, the pursuant to the judgment of the Honorable Supreme Court in 1990, Government of India also had issued a circular.
Number 3 was promoted when?
Yes. Number 3, my lord, he is facing the disciplinary inquiry.
No, number 4 is faced.
Number 4. 3, my lord, it doesn't have the, because that is one of the grievance which I raised, saying that, my lord, that I also place reliance on annexure D. The fact that it doesn't have, now the selection committee doesn't have power so as to relax it, either under the rules nor that was, my lord, stated, so even in the recruitment notification at annexure A. Recruitment notification is silent.
Sorry. Hold
Let
on.
may make one submission, my lord.
There is nothing
I-
you are,
Now, the question is this, my lord, I also produced annexure D because I have also referred some judgment of the apex court on the same issue, saying that, my lord, that when the selection committee, my lord, doesn't have such powers. When the thing is forthcoming, the selection committee, my lord, annexure D, you will also kindly see, my lord, page 59.
59.
Yes, my lords. Typed copy I have produced.
93.
Yes, the subject, this one, action against the government servant to be taken if they are later found ineligible or unqualified for their initial recruitment. Now, we are referring to this, para 2, a question has now arisen as to whether the government servant can be discharged from service and it is discovered later that the government servant was not qualified or eligible for his initial recruitment in service. The Supreme Court in the judgment in the district collector was M. Tripura Sundar Devi, 1994 SLR 237, went into this issue and observed as under. It must further be realized that all the consent that when an advertisement mentions a particular qualification of an appointment is made in disregards of the same, it is not a matter only between the appointing authority and the appointee consent. The aggrieved are also those who have similar or better qualification than the appointee or appointees, but who had not applied for the post because of they did not possess the qualification mentioned in the advertisement. It amounts to a fraud on the public appoint. A person with inferior qualification in such circumstances, unless it is clearly stated, qualifications are relaxed. No court should agree to the perpetuation of the fraud practice. The matter has been examined in consultation with the Ministry of the Law and Justice. It has been now been decided wherein it is found that the government servant was not qualified or eligible in terms of the recruitment rules for initial recruitment in service or had furnished false information or produced false certificate or in order to secure employment, you should not be retained in service.
Heard learned advocate Mr. So-and-so for the appellant. The present appeal under section 4 of the Karnataka High Court Act 1967 is directed against judgment and order dated 20th September 2024 of learned single judge, whereby the writ petition of the appellant petitioner came to be dismissed. Paragraph. In the main petition, twin prayers were made by the petitioner. First was to set aside endorsement of the order dated 18/4/20, endorsement of the communication dated 18/4/24, issued by the Chief Personnel Manager, Karnataka State Road Transport Corporation, dash respond number 2 herein, whereby the grievance of the petitioners about his promotion was not entertained. They said endorsement of the communication dated 18/4/24, figures on record. Which turns down the request of the petitioner, which was in the nature of grievance in respect of the promotion given to respondent 3 and respondent 4 here. In respect of consideration of respondent 3 and 4 for promotion, the post of law officer. The second paragraph, the second limb of the prayer was for directing respondent number 1 and 2 to conduct the departmental promotion committee and consider the case of the petitioner for the post for the promotion to the post of upper law officer and chief law officer, for promotion to the cadre of chief law officer into the selection grade 1 and extend consequential monetary benefits. Full stop. Objecting to the paragraph, objecting to the promotional avenues, promotional rights considered for response 3 and hearing, comma, it was stated by the petitioner that said respondents were appointed and reported to the post on 30th/11/1999, whereas the petitioner was appointed and reported on the post, initial post, on 10/2/2000. Thus, when appointed as law officer, the petitioner was admittedly junior in terms of appointment and joining the duties compared to say discipline 3 and 4. Full stop. According to the petitioner, response 3 was not, 3 and 4 were allegedly not eligible to be given promotion, as response 3 did not possess the requisite qualification about the experience at the time of his appointment to the post of law officer. About respondent 4, what was alleged was that he was facing certain disciplinary action. And it was the contention of the petitioner that unless the said disciplinary proceedings were concluded, the promotion could not be given to said respondent 4. Paragraph. The petition was contested by the respondent authorities, who submitted that the petition had raised grievance belatedly as regards the case of respondent 4 belatedly after the appointment of respondent 3. Full stop. As regards the consideration of promotion of respondent 4 was concerned, it was stated that respondent 4 was facing the disciplinary inquiry proceedings, which was still under progress. It was stated that when the Department Promotion Committee would meet, it would consider the case in a sealed by undergoing a sealed cover process. Full stop. About the promotion given to respondent 3 was concerned, it was a clear case that it booked no irregularity. Paragraph. While dismissing the petition, learned single judge took note of the aspect that the grievance raised by the petitioner was at a belated stage. The petitioner was due to retire within short period of 11 months. At that juncture, the petitioner questioned the eligibility of respondent 3, who was already promoted. Learned single judge observed respondent 3 was actually found to have possessed all the requisite eligibility criteria, and that he was senior to petitioner. Therefore, was given promotion to the only available vacant post as chief law officer. Full stop. Learned single judge was justified in viewing that the promotion cannot be claimed as a matter of right, more particularly when that the grievance are to be put forward by the petitioner was smart amenability, indolence, and was a belated attempt to question the eligibility of responsibility, which was even otherwise factually not tenable. Full stop. No case is made out to interfere with the judgment and order on a single judge in the appellate jurisdiction. The appeal is dismissed.
Still number 17. So Srinivas.
For appellant in this case, but the appellant
15 days delay,
19 days delay, my lord.
returnable on
Lord, I think BLC duty.
11th March.
Number 18.
Appearing for the appellants.
Then-
We have sought a prayer to set aside the order
So
passed
it
by
is
the.
based on the Supreme Court judgment. You can't challenge the preliminary notification or acquisition unless the final is issued. Dismissed. Dismissed. Yes, next.
It's transfer, no?
Transfer.
In 21, my lords,
21 is
It is
still to reach, Mr.
sorry, still number 18, my lords.
18, yes, 18, what happened?
How different?
18,
again, there's a delay, my lord.
This is service matters. 19 is created.
19 is dismissed. no?
Please.
19 blood dial. So 18 now.
But 18 is transfer. It's service.
18 is, it is yet to, yes,
Please.
18.
What's, is it, application for delay also, my lords,
Delay also.
Please.
So notice it.
notice me, please.
Notice it on 21st February.
Number 19. Number 19. The preliminary notification is challenge. I agree that, my lord. Kindly
So
see.
19 is same, ne? Preliminary notification.
Preliminary notification. Yes, my lord. This court, my lord, I'll just take one to lordship through one judgment passed by this honorable court, where, my lord, this court has interfered at the stage of 28-1. That is the preliminary. I'll show that. And that has been
Let us-
approved by the Supreme Court also. Kindly see, my lord, the
This order of learner single is based on this
HMT, my lord.
2007-9 SCC 760.
Yes, my lord. That, my lord, kindly see what has happened.
HMT, yes.
Yes, HMT. That judgment, my lord, came in the year February 8, 2007. Now, my lord, we are seeking dropping of the lands from preliminary notification based on the circulars issued by KADB, which came in March 2007. So that was in the HMT judgment, the circulars of KADB was never called into question because it came after the HMT judgment. Now, kindly see on the very same factual circumstance, this court very recently interfered at the stage of 28-1. And that has been approved by upheld by the Supreme Court. Kindly see that judgment. I've produced the memo. The first judgment, my lord, is the order of the learned single judge. Page number 9, my lord, is the judgment of this honorable court. Page number 9, my lord.
Page number?
Page number 9 of the memo, my lord, which I've just produced to your lordships. This is the order of this honorable court, wherein 28-1 was challenged. That came to be upheld solely on the ground that, my lord, the land was converted and circulars were not taken into consideration. My case is also very similar. In my case also, pursuant to no objection given by KADB, I go ahead and convert the lands from agriculture to industrial purpose. And thereafter, my lord, 28-1 came to be issued. In the case before your lordships,
There appears to be different.
no, my lord, kindly say, I'll take your lordships to the facts also. Lords may kindly say the order passed by this honorable court. Page number 15, para number 5. These circulars came pursuant to the HMT judgment. So HMT judgment were at the time wherein the preliminary notification cannot be challenged. These circulars were never into consideration at all.
What was that circular?
The circulars, my lord, what had happened, I'll produce the circulars. So at the time of issuance of preliminary notification, the KADB has to do a spot inspection and see whether some of the lands have been converted for industrial, because ultimately what KADB wants to build an industrial layout. Now the lands have already been converted for industrial purpose, and then already an industry been set up. There's no point of reacquiring and reissuing again. So they have to go through that exercise. So with respect to that, two circulars came to be issued. One on 3/3/2007 and the second one on 18/3/2013. Both say that once the lands have been converted, those lands cannot be considered for 28(1). Now, without following that circular, they have issued this 28(1). That was the question before your lordships in that writ appeal, my lord. That came to be considered. This court has held that in page number 15, para number 5, the circulars dated so and so on which challenge to legality of acquisition of the petitioner's land is rested are on record. Both the circulars deal with the procedure to be adopted for acquisition of land on behalf of the board for industrial purpose. The circular dated so and so was issued since it was notified by authorities of lands were being acquired without verification and that certain lands and structures such as so and so have not been considered. Thereafter, this
Here it is converted.
yes, ma'am. I produced the conversion orders also. Converted for industrial purpose, not for residential purpose, for industrial purpose. Pursuant to conversion, they had filed two petitions. This is a common order which was
So your
passed.
development agreement is post conversion.
Yes, ma'am.
Naturally.
Yes, yes,
Has to be.
yes,
After conversion.
yes. Now, what has happened, my lord? Without following that exercise, they en masse, my lord, they issue a 28(1) notification. Now, this court on multiple occasions have held that conduct that exercise and that these circulars have been given statutory effect.
Notice written. Yes, who appearing? You are appearing, Mr.
ADB has to be notified.
Only K.
Respondent number 2, my lord, I am appearing. I'll take notice for respondent number 1.
Where you have stated that it is converted to industrial purpose
Please, my lord. I filed the annexure also
in your petition.
in my petition, my lord. Annexure page 100 in my petition, writ petition. I'm sorry. For a moment. Page number 28, para number 6.
6.
6.
Yes. Yeah. So, subject to what they say, this judgment will apply.
My lord, in the joint development agreement, my lord, the land is shown as agricultural land, my lord. Joint development agreement is at page number
Parallelly, it
42.
happens.
But
The lands are described as
has been
agricultural
converted.
land.
the
Conversion-
scheduled property in each survey number got converted to non-agricultural purpose by the official memorandum issued by the district commissioner on 20th.
Even before that, we had obtained no objection from KADB, whether these lands are subject to acquisition or not. They've issued two no objection certificates. But in the meanwhile, my lord, let them, the order of status quo be maintained. For this reason, tomorrow, my lord, they'll come and occupy the land. The grievance is that. Let there be an order of status.
While assailing the
This is the reality.
judgment and order of law on a single judge.
Lord, physically, my lord, what happens, my lord, I'm fighting against the state and it's a large extent of land.
Council, unless 28(4) is issued, where is the question of
That is,
possession?
that is why, my lord, I'm seeking only an order of status quo, neither be not them.
While assailing the judgment and order of law on a single judge who dismissed the petition of the petitioner, challenging the acquisition on the ground that it was only at the stage of issuance of preliminary notification under section 28(1) of the KID Act, and therefore was premature. Our learned advocate Mr. So and so relied on decision of this court. Where is that?
In the memo, my lord, filed now. In writ appeal number 39 of 24.
In the writ appeal number
39 of 24. Thereafter confirmed by Supreme Court in SLP number 11156 of 24. That is at page number 22.
39 of 2024, decided on 11th March 2024, which came to be confirmed by the Supreme Court in special leave to appeal interpret C number 11156 of 2024. For order dated 13/5/20. Reliance was placed on the circular dated 6.
3/3/2007.
Which one?
3/3/2007.
2007, which contemplates that where the land is converted from agriculture to industrial purpose, comma, it shall be spared from acquisition. Paragraph, notice returnable on 20. On 3rd March, first of the respondents are directed not to take any precipitative text.
Please. Great. Great.
Delay. Notice returnable on 4th March.
Number 21, AMB Chandrachud.
The respondent number 6.
So order of learner single, you already stayed.
Please.
What
They
is the
took
order?
time to file objection.
I seek time to file objections.
You want to file objection. Learner Mr. Swanshu wants to file statement of objections. Time is granted.
R6.
R6.
Stand over to 4th March.
Please. Interim order to continue.
Interim order granted 30/12/24 by the coordinate bench shall continue to operate till the next date. Please.
This. So ready notice matter, seal number 22.
Dear
To
for the
seek
plain, my
and
lord. In this matter, my lord, what is sought to be challenged is order of the learned single judge. In so, what had happened was BWSSP, while issuing, when there was a request for issue of NOC to obtain building sanction plan and development plan, demanded NOC for the regulations demanded NOC. We applied to BWSSP. BWSSP charged, demanded various charges. 2 charges were advanced pro rata charges and 1 BCC towards Greater Bangalore. We challenged that only on those 2 we challenged in the writ petition. The writ petition court held that demand of advanced BCC is wrong, but upheld advanced pro rata charges, my lord. But my lord, what had happened is in this matter, the reasoning is that this order is passed on 22nd of April. On 5th of April, there is an order passed in some connected matters, some matters. Therefore, in the same way, this is also dismissed, my lord. The contentions are not in entirety considered, only on the position of law that is done. And there is a delay, my lord, but it is not 106.
Connected writ appeals involving the same.
Yes, my
question,
lord, correct.
On the pro rata basis, there are connected writ appeals where notices have been issued. BWSSB is the.
Correct. Notices are issued.
Please, my lord, there are batch of matters, my lord, I will pass on the numbers.
So we'll condone the delay.
My lord, there is a delay.
There's also delay, my lord.
All are served.
106 days delay.
My lord, it's not 106 days. The calculation is wrong. It comes to 48 days. What had happened, my lord, it was order passed in many matters.
All are served.
No, my lord, respondent number 2 is BWS.
Served.
Yes, served.
Served.
Very well. Board, my lord.
Served, my lord.
Who is the counsel who appeared in the writ proceeding?
Mr. Sanjeev, my lord, BL Sanjeev appeared.
You copy.
My lord?
You copy to Mr. BL Sanjeev.
No, I'm Srikara, my lord. I have appeared.
We know about respondents counsel.
We'll serve a copy. We'll serve. The writ appeals connected are posted to 21st, my lord, in one of the matters.
But for the purpose of condoning delay, you please give copy to Mr. Sanjeev.
Yes, my lord. Will do, my lord.
We'll keep it, they will give, we'll keep it on Monday.
Yes,
Monday at 2:30.
Sir, Mr. Sanjeev.
learned advocate for the appellant shall furnish copy of the appeal as well as the condemnation application to learned advocate, Mr. BL Sanjeev,
BL Sanjeev.
who would appear for his own to put up at 2:30 on 20th January 2024. Hi.
Number 23, Tarun BM.
For respondent, two, please. Or five. For the petitioner in this matter.
Appear for respondent three, my lord, in this case.
Challenge to appointment of fifth respondent, initially as associate professor and later on as professor at the Bangalore University, contrary to the UGC guidelines, my lords. Lords, initially they have taken up the contention that a writ of quo warranto is not maintainable. I am relying upon the judgments in Hariban's Lal. They themselves have cited that. And then Gambhirdan, my lords, Gambhirdan K. Gadvi, State of Gujarat. In that, the Honorable Supreme Court in 2022 has laid down the law. Once UGC regulations are violated, a writ of quo warranto is maintainable and the appointment has to be set aside. I have passed on that judgment on the last occasion, my lords. Gambhirdan K. Gadvi. Supreme Court has laid down the law in respect of qualifications under the UGC Act.
Other judgments are there, but not the one you are referring.
Sorry,
Mamta Mohanty.
no, that is compilation. But later on, I passed on that judgment. After last date of hearing, your lordship directed me to pass on that judgment. Separately, I passed on the judgment. 2022 5 SEC. Gambhirdan K. Gadvi. I'm sorry.
It is there.
The maintainability, they have settled the issue, my lords.
The post of a vice chancellor.
Para 48, my lords. No, both the here also, the UGC regulations will apply. Kindly see para 48 for a moment, my lords. Other paragraphs are there. I'll read only for maintainability. It is clear that the respondent state of Gujarat has failed to take note of the communication from UGC, and instead the respondent university has left it to the sweet will of the search committee to prescribe eligibility criteria for the appointment of the vice chancellor of the university. The eligibility criteria, when once fixed by the UGC under its regulations, would in our view apply to all universities which are aided by the UGC to be bound by the said regulations, even in the absence of same being incorporated in respective universities act of the respective states. Therefore, when the appointment of respondent number 4 is found to be contrary to UGC regulations 2018 and UGC regulations are in statutory force, we are of the opinion that this is a fit case to issue a writ of quo warranto and to quash and set aside the appointment of respondent number 4 as vice chancellor of the SP University. Same facts, my lords. Here only thing is he is a professor, associate professor, UGC Act under that career advancement scheme he has applied. His application itself under his career advancement scheme of UGC.
Para 19 of the same judgment.
My lords, well, his parallel arguments is not proper.
Para 19 of the same judgment, my.
Let us see the facts.
Please.
Let us see the facts.
My lords, may kindly see the short synopsis filed by me. I have filed a short synopsis, my lords. Short synopsis. What else? Ready. Copy. I'm sorry. I'll give. Lordship maker. Lordship, may kindly see para 3, my lords. Fifth respondent was promoted to the post of associate professor on 19/12/2017, page 26. In respect of that, your lordship may kindly turn to page 3A, application, annexure D, page 54. Date of eligibility 1/7/2015. He had also submitted research publications and academic contributions as per category 3A of UGC regulations, page 62. Lordship may permit me to peruse page 54, my lords. His application itself is under UGC regulations. Annexure D. I will not read the entire thing. Page 54, my lords, in the light of the my lords may kindly permit me, page 54, annexure D, my lords. My lords, my endeavor will be in this matter for the present, my lords. University, after this matter was filed, has now installed the required software for detection of plagiarism. My lords may have to call for the report from the university based on the software they have installed subsequent to filing of this writ petition. On the date of filing of this writ petition, software was not installed in terms of the UGC regulations.
What is the post here?
Professor.
Associate professor.
Professor, my lord. Subsequently, before he became assistant professor, I had complained that he has indulged in plagiarism, both to the university and the honorable chancellor. And nothing has come out of that. Now the university doesn't dispute. Paragraph number 11, I made a direct allegation that he has indulged in plagiarism. The university admits that it has not complied with the UGC regulations in installing the software. Therefore, earlier occasion, this court directed.
My lords, the post of the professor is not a public office, my lords. Co-warrantor lies only on assumption of a public office, my lords. Post of a professor, section 11 of the Karnataka State Universities Act is very clear, my lords.
So that is fundamentally provided, fundamental whether the court.
In fact, this honorable court, my lords, way back, my lords,
Should be only in respect of
also.
holder of a public.
No, that was earlier to UGC regulations being made applicable. Now, kindly see the honorable.
Post of associate officer is public office.
No,
Yes,
please not, no,
yes,
my lords.
yes.
You have
No.
to set it.
I will demonstrate, my lords.
Section 11.
I will
of-
demonstrate it's a public office.
Section 11 of the Karnataka State Universities Act.
Doesn't include associate.
It includes.
It's not,
Doesn't
doesn't include the post of professors. Officers of the university, it includes the chancellor, pro-chancellor, vice-chancellor, registrar, registrar evaluation, dean, librarian, finance officer, director of planning, monitoring and evaluation board, director of students welfare, director of college development council, director of physical education. These are the officers of the university.
Section 27, my lords, authorities of the university.
Please,
It contains faculty.
faculty has been explained in section 34, my lords.
So following shall be authorities of the university. Faculty is
Faculty should consist of readers, lecturers, professors. Professor by itself is not a post of public office.
We'll assemble after
please.
10:15.
Number 20.
So we have to, you have to demonstrate that it is a public.
Please, my lords. Your lordship may kindly take Annexure D, page 54, is application. His application was under the UGC Act. Annexure D, page 54. Performance based, when he became associate professor, heading, my lords, performance based appraisal system for promotion under career advancement scheme as per UGC regulations. Here itself I'll tell what is my grievance, my lords. Your lordship may kindly turn to page 62.
62.
This is the grievance, my lords. Here itself I'll. Page 62, category 3, this is prescribed by UGC under its regulations. Research publications and academic contributions. Published papers in journals not indicate the API score for each paper as per UGC prescribed act. Page 62, top, my lords. Research publications and academic contributions. This he has plagiarized. These papers what he submitted is plagiarized. I'll demonstrate that, but I'll demonstrate regarding maintainability first, my lords. Plagiarized. He has plagiarized. And the university had not installed the software as per UGC directions. And this concept of public office is limited to certain posts. Other posts, statutory rules now, Harbans and Gambhir Gadvi both say, if you are violating statutory rules, co-warrant has to be issued. If you UGC regulations are violated. This
Plagiarism, you can't say that it is.
No, I will demonstrate. Plagiarism is a.
University to say that these.
Please, my lord.
Papers are plagiarism.
No, I will demonstrate, my lord. Kindly see.
By plagiarism.
Kindly see Annexure D1, my lords. UGC regulations, which was applicable for his promotion.
Next, sir.
D1, page 70, my lords.
Yes.
Your lordship may kindly see the date, 11th July 2016. He was promoted on 19/12/2017. So this became applicable. His short synopsis I have shown. He was promoted on 19/12/2017. This became applicable on 11th July 2016. 1.1, I may be permitted to read 1.1. These regulations may be called University Grants Commission minimum qualification for appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in higher education. They are very clear. Second one, they shall apply to every university established or incorporated by and under a central act, provincial act or a state act. Now the Karnataka State Universities, Bengaluru University is under Karnataka State Universities Act. So it is established under a state act. Every institution, including a constituent or affiliated college, recognized by the Commission in consultation with university concerned under Clause F of Section 2 of University Grants Commission Act, and every institution so and so. Your lordship may kindly turn to page 71. The regulations are at class 2. Regulations are at class 2, page 70. 71, appointment of teachers. On the right hand side, there is an amendment. Appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in higher education. Your lordship may kindly come below 6.0.5 Roman 1, same page 71. 6.05 1. The university shall identify the journal subject-wise through the subject expert committees and forward the recommendation to UGC in format prescribed UGC for approval of the UGC Standing Committee. The journals approved from this list by the UGC Standing Committee shall be included in the list of journals notified by the UGC. This is not complied by the university before accepting his thesis. Now kindly turn to page 72. Whether he is a holder of an office under a...
Where did you read?
Page 71, my lords. Page 71. Your lordship may kindly see 6.05. That is amended.
6 point.
Yes, my lords. 6. First one I am reading, relying upon 6.05, last one, this one. The amended portion is on the right side. Amended, the university shall identify the journals subject-wise through subject expert committees and forward the recommendation to UGC in the format prescribed by UGC for approval of the UGC Standing Committee. The journals approved from this list by the UGC Standing Committee shall be included in the list of journals notified by the UGC. The UGC Standing Committee shall give its recommendation within 60 working days of the receipt of the list from the university. UGC Standing Committee may also so moto recommend journals for inclusion in list of journals. Without this list of journals, no PhD can be granted, my lords. No journal can be accepted. He has got that without this being there on record.
So there are no journals.
No, it is admitted fact. Now they are brought out with the software for detection of plagiarism. Now recently, after this writ petition was filed, kindly see page 72. That clinches the issue. His appointment is under UGC regulations. Page 72. Next page, my lords. In the same regulation.
No, again, you are on the aspect of lack of eligibility.
No, that is what the Supreme Court says.
But not on the, we want you to address on whether it is.
Yes, I will address, my lords.
Public office.
Yes, please, my lord. If he doesn't have qualification, based on the journal being plagiarized, he can get an appointment. That is what my contention is. Kindly turn to page 72, my lords.
No, again, you are on eligibility. You are on whether the post of associate professor is a public office.
That public office, that is what I am coming to. Statute is under a statute. Kindly turn to page 72. My lords, I have to demonstrate to this honorable court that appointment is under a statute. That the Supreme Court has made one progress in this matter, stating that if it is not under a statute, then it has to be set aside. If the appointment is as per statute, if it is not complete, quo warranto will lie. That I'll read the two judgments of the Honorable Supreme Court. Kindly see page 72 for a moment. Contrary to the statute, I'll demonstrate that, my lords. Page 72 may kindly be seen. I am now demonstrating that this appointment was under a statute.
Mr. Arun, first you satisfy that this is a public office.
Yes.
Then we will go into
that is what
other
I'm
things.
demonstrating. That they kindly
So first, what is the definition of public office? Where do we get it? What is the definition of public office? What can be termed as a public office?
Two more portions and then I'll come to public office in the Supreme Court judgment.
We want that first. Of public office. Now you are taking us through plagiarism.
Yes.
Saying that because he has done plagiarism.
Not plagiarism, my lords. He was not, if he was not eligible under the UGC regulations, UGC regulations say that these are the qualifications. That qualification he didn't have.
We'll come to it later.
That's right.
First, you have to show that post of assistant professor for which they were recruited is a public office.
Kindly see page Universities Act, section 27. Play 27 minutes. My learned friend read other section, Vice Chancellor, 27. Authorities of the university. All others, writ petition is maintainable because the faculty comes under service, quo warranto is maintainable. The E, 27E. I'll demonstrate, my lords, from the Supreme Court judgments. E comes, faculty comes under a statute. Is appointment.
So if any post comes under the statute, it automatically becomes public office?
Yes, my lord. That is what the Supreme Court says. I'll demonstrate from the judgment. Now kindly see whether it is a statutory post. Your lordship may kindly turn to page 70. No, 72. In that 72, my lords, for a moment.
Complete the link of chain of your argument.
Yeah, there itself, my lord. 72, your lordship may kindly see.
70.
If 70 it starts, 72, your lordship may kindly see. Appendix 3, my lords, down below. This is the qualification prescribed by UGC for one to become an associate professor. Academic performance indicators, API, for career advancement scheme, CAS, promotions for assistant professor, associate professor, and for direct recruitment of associate professor and professor in university and colleges. This is the requirement. This requirement he doesn't fulfill. That is what I am not eligibility, my lords. He is not eligible to be appointed. Kindly see in that page 74, category 3. This research and academic contributions, if he doesn't qualify, he is not fit to be appointed as a associate professor. 3A might kindly be seen. 3A in that at page 74, 3A. Research papers published in. This he doesn't qualify. Research papers published in referred journals as notified by UGC. My lords may kindly note UGC. I'll come to the Honorable Supreme Court judgment. Other reputed journals as notified by UGC. So his minimum score on the right-hand column, 25 per publication as per referred journal and 10 per publication. That will be a qualification for him to become an associate professor. If he doesn't have that, then he will not be eligible to become. Now I'll come to the next year, my lords. Now kindly see the selection committee proceedings. Only one paragraph. Kindly turn to page 90, my lords. What was in the mind of the selection committee? Honorable Supreme Court has commented on this also. Kindly see the selection committee proceedings at page 90. Department of Life Science. When his selection was put through, the selection committee perused the application, biodata with the performance appraisal reports of so-and-so, assistant professor, grade 3, Department of License, Bangalore University. As per the UGC regulations guidelines contained in notification number so-and-so, subsequent UGC amendment 2013. So both his application was under UGC regulations, his selection was under UGC regulations. Now, whether he has violated the UGC regulations, that is a point. Now, whether he is plagiarized in producing that journals, he will produce the journals, my lords. Now, there is no opportunity for me to challenge in a writ petition because I am not a rival this one. I am a public spirited citizen. My only remedy is quo warranto that I will demonstrate, my lords, in this appointment. Now, kindly see the second appointment, his application. Your lordship may kindly turn to page 196, Annexure M, for professor. He was promoted on 12/2/2020, serial number 4 in my synopsis. 12/2/2020, he was appointed. Kindly see the regulations at dated, it is dated 2/2/2019. He had filed this application for being promoted. Now, your lordship may kindly turn to UGC regulations applicable on that day, page 96, my lords. Page 96. Annexure F. The regulations itself use the word academic integrity. UGC, your lordship got page 96, my lords. This regulation say that plagiarism has to be curbed, my lords. Kindly see this one. University Grants Commission Promotion of Academic Integrity and Prevention of Plagiarism in Higher Educational Institutions, Regulations 2018. These, your lordship may kindly skip to clause 1, rule 1, regulation 1, short title, application and commencement. These regulations will be called the University Grants Commission Promotion of Academic Integrity and Prevention of Plagiarism in Higher Educational Institutions. Your lordship may kindly see this regulation 4, my lords, at page 98. Page 98, regulation 4. Every higher education institution should establish a mechanism as prescribed in these regulations to enhance awareness about responsible conduct of research and academic to promote academic integrity and to prevent plagiarism. Without installing this, university has granted promotion to him. And when, especially when a complaint is there that he has indulged in plagiarism. Page 96 it starts, 98 it's this one. Kindly see UGC regulations. I'll skip the other things. There are several things how a plagiarism has to be dated. I'll not go into that. Your lordship may kindly see page 100. What UGC prescribes. If he has indulged in plagiarism and he is promoted, what happens to his academic this one? My lords may kindly see note penalty at regulation 12.2, my lords, page 100, penalty. Penalties in case of plagiarism in academic and research publications. Your lordship may come down to note 2, my lords. Note 2. Penalty in case where benefit or credit has already been obtained, that has happened in this matter. If plagiarism is proved on a date later than the date of benefit or credit obtained as the case may be, then his or benefit or credit shall be put in abeyance. That is what the UGC says. I can't challenge it in writ petition matters because service matters writ is not maintainable. I'm not a rival claimant. He'll go scot-free. Nobody can challenge. He'll be working in the university. Whence for a period recommended by institution academic inquiry panel and approved by the head of institution. Now, I will come to the judgments of the Supreme Court. If his appointment is under UGC, what is this one? Your Lordship may kindly see Hariban's law. This is in the compilation produced by learned friend. Page, no? In the page, no? Hariban's law. 2010 compilation. 2010. In the second compilation filed on 5/8/2021, the Lordship may kindly turn to compilation number 3, judgment number 3. Only 2 paragraphs in the judgment. It starts at page 28, filed on 5/8/2021, my lords. The respondents have filed that citation. The Lordship may kindly skip to the Honorable Supreme Court has extracted the statutory provisions at paragraph number 8, my lords. What was involved in that matter? I will not read that law because law laid down by the Supreme Court is at page statutory provisions are extracted at para 8. Then Electricity Supply Act. Your Lordship may kindly turn to paragraph number 11, page 33, para 11. About maintainability of public interest litigation in service matters, except for writ of quo warranto, there are a series of decisions of this court laying down the principles to be followed. It is not seriously contended the matter in issue is not a service matter. In fact, such an objection was not raised and adjudicated before the High Court. Even otherwise, in view of the fact that appellant herein was initially appointed and served in the State Electricity Board as a member in terms of section 5(4) and from amongst the members of the board, considering the qualifications specified in subsection 4, the state government, after getting a report from the Vigilance Department, appointed him as chairman of the board. It is impermissible to claim that issue cannot be agitated under service jurisprudence. Kindly turn to para 15. Para 15 at page 34. The above principles make it clear that except for a writ of quo warranto, public interest litigation is not maintainable in service matters. Then para 16. Writ of quo warranto. A writ of quo warranto lies only when the appointment is contrary to a statutory provision. In High Court in Gujarat, so and so. I will not read that. Then in the same judgment, para 16, last 3 lines. A writ of quo warranto can only be issued when the appointment is contrary to statutory rules. Then your Lordship may kindly turn to para 19. It is clear from the above decisions that even for a issuance of a writ of quo warranto, the High Court has to satisfy the appointment is contrary to the statutory rules. In the latter part of our judgment, we would discuss how the appellant herein was considered an appointment as chairman whether he satisfied the relevant statutory provisions. I'll skip that, my lords. I'll come to this Gambhirdhan's case, my lords, of the Honorable Supreme Court latest judgment interpreting the UGC Act 2022 5 SCC 179. Though it was Vice Chancellor, the Supreme Court says when it is under UGC Act, it is a statutory appointment. It has to be set aside. Lordship may kindly turn to para 1. What was in issue before the Honorable Supreme Court? Only 2-3 paragraphs I'll read. By this writ petition, under Article 32 Constitution of India, the petitioner has prayed for a writ of quo warranto, challenging the appointment of respondent number 4 as Vice Chancellor of the respondent number 2 so-and-so university and to quash and set aside the notification dated bearing number so-and-so. Passed by the respondent number 1 state of Gujarat, appointing respondent number 4 as Vice Chancellor of the university so-and-so. My lords may kindly skip to para 2. it is the case on behalf of the petitioner that the UGC Grants Commission, University Grants Commission framed UGC regulations on the minimum qualification for appointment of teachers and other academic staff in universities and colleges, and measures for maintenance of standards in education so and so, which inter alia prescribed regulations say that a person shall have 10 years of teaching experience as a professor in university system. It also provides for constitution of a search committee consisting of a nominee of the vice chancellor, a nominee of the chairman so and so, a nominee of the syndicate, that the search committee has to recommend the names of the suitable candidates for appointment. That the UGC regulations 2010 has been substituted subsequently by UGC regulations 2018 with slight modification which shall be referred to. I am relying upon these two regulations, my lords, in this matter, 16 and 18. Then your lordship may kindly turn to para 2.5. The UGC addressed a communication dated 11/8/2014 to His Excellency the Governor of Gujarat seeking compliance with the UGC regulations 2010 with respect to appointment of vice chancellors in the state of Gujarat. That His Excellency the Governor of Gujarat communicated to the Government of Gujarat by communication dated to comply with the UGC regulations with respect to appointment of vice chancellors. At this stage, it is required to be noted that His Excellency the Governor of Gujarat is the ex officio chancellor of all the universities in the state, including the SP University. My lords, in this matter also, UGC has written to all the universities that appointment to these posts should be under the UGC regulations. I will read that later on. But the UGC addressed a general communication to all the universities in India that they should comply with these directions. Then your lordship may kindly see paragraph number 3. That the petitioner challenged the said appointment of respondent number 4 before the High Court by way of special civil application by judgment and order dated so and so. The division bench of the High Court dismissed the said so and so by observing and holding that UGC regulations had not been adopted by the state of Gujarat and thus were not binding upon respondent university, while dismissing the so and so and upholding the appointment of respect to the post of vice chancellor of the university. The division bench of the High Court referred to section 10 of the so and so Act, which does not provide for any qualification whatsoever for appointment to the post of vice chancellor. The division bench of the High Court observed that such a position would leave room for a lot of arbitrariness in the matter of selection of persons for appointment as vice chancellor. Then your lordship may kindly turn to para 5. That thereafterwards, an advertisement dated so-and-so was published, inviting application to the post of Vice Chancellor of respondent number 2 SP University. According to the petitioner, again the search committee was not constituted as per UGC regulations. According to the petitioner in the said advertisement, the search committee has further diluted eligibility criteria to suit respondent for insofar it states that persons who have remained Vice Chancellor for one term are eligible.
Consider their version.
I'm sorry.
We understood, yes.
That's regarding to the maintainability, my friend referred to section 30.
So he is saying that by virtue of section 27.
Section 34, section 34 may kindly be seen,
34.
Please, which defines faculties. What is faculties?
No, we know, we want the attributes of public office for the purpose.
Please,
of forward.
Please, I've produced the judgment,
When it is there, you just.
I've produced the judgment, First judgment, in the memo dated 24/6/2021.
You go in your own way.
Please.
34.
Section 34. Defines faculties, my lord. The university shall have the faculties of arts, commerce, education, engineering, law, science and technology, and such other subjects as may be prescribed by the statutes from time to time. Each faculty shall consist of so and so shall consist of such number of department of studies as may be assigned to it by the ordinance. The department of studies in each faculty shall consist of following members, which will include the post of lecturers, teachers, and I'll directly come to the judgment, my lords, which I've relied upon, my lords, in the memo dated 24/6/2021. Directly on the point, my lords. The first judgment First judgment, my lords, of our High Court, my lords, way back, my lords, in 1964. Para 14, my lords, I think page 9. This was a challenge by way of quo warranto to the post of professor, my lords.
That is one of the main judgment on forum. Please. Yes, paragraph
14, my lords, in page 9.
On page 9.
In page 9. Yes. Now, in the case before us, the posts held by the contesting respondents are of a professor or of a reader in physics, like para 14, in page 9, para 14, my lords, at the bottom. In reader in physics at the University of Mysore. They are certainly not posts or offices created by the Constitution. Section 13 of the Mysore University Act in parameteria with Karnataka State Universities Act, my lords, gives a list of statutory authorities of the university. The Senate, Syndicate, Academic Council, the Faculties, Board of Studies, Board of Appointments, Committee of Finance, and such other bodies as may be declared by the statutes to be the authorities of the university. Let's no declaration under clause H assimilating the position of professors and readers to a statutory authority of the university has been brought to our notice, nor is there any provision of the Act which enumerates or designates professors, readers, or teachers as statutory functionaries in the same way as functionaries like the Chancellor, Vice Chancellor, Registrar to have been. Professors and readers of the university clearly do not exercise any governmental functions, nor are they invested with the power or charged with the duty of acting in execution or enforcement of the law. They are merely employees under the statutory body. They cannot therefore in any sense be described as holders of public office in respect of which a quo warranto will lie. That's followed by that, my lord, Supreme Court judgment, my lords, in page 15. In page 15, my lords, AR 1965 SC 491. Relevant portion, my lords, at in page 18, my lords, in page 18. First, the top para, my lords, the last 4 lines may kindly be seen, my lords. Last 4 lines. It is thus clear that, let's get that, my lords. The first para, last 4 lines, my lords, corner. It is thus clear that before a citizen can claim a writ of quo warranto, he must satisfy the court inter alia that the office in question is a public office and is held by a usurper without legal authority.
Where you are reading?
My lords, top para, last 3 lines. My lords, get that.
Yes.
Usurper without legal authority, and that necessarily leads to the inquiry as to the whether the appointment of the self-alleged usurper has been made in accordance with law or not. That's the next judgment.
That's next 2 paragraphs in that judgment.
Please, my lord.
So, Honorable Supreme Court, next 2 paragraphs, 8 and 9. Statutory rules were not placed before the High Court.
I may complete. Para 8, my lords. In the present case, it does not appear that the attention of the court was drawn to the aspect of the matter. The judgment does not show that any statutory provisions or rules were placed before the court, and that in making the appointment of appellant number 2, these statutory provisions had been contravened. My lords, the matter is that, my lords, is not discharging any public duties as a professor. My lords, the first judgment is on the point. My lords, following this, my lords, Allahabad High Court.
Paragraph
My lords,
also, 8 and 9 are very clear by the.
falling back on the same judgment, my lords, Allahabad Court also, my lords, said professors are not the post of public office, my lords. Para 2, my lords. By means of this petitioner, the petitioner has prayed that a writ in the nature of quo warranto be issued directing the opposite party number 3 to show the authority of law under which he occupied the post of associate professor and professor in King George Medical University, Lucknow, hereinafter referred to as KGU in short, thereby declaring his appointment on the post of associate professor and professor to be illegal and void ab initio. That's para 10, my lords. Next page. Para 10. This is a trite law that the doctrine of delay and laches are not applied if the writ of quo warranto has been prayed, and the writ of quo warranto may be prayed if any person is holding an independent substantive public office without having any legal authority to that effect. In other words, the constitutional courts are to see that a public office is not held by a usurper without any legal authority. It is also trite that the concept of locus standi does not play role if a writ of quo warranto is prayed, but At least the contention of the petition should be bona fide in as much that it should not appear that a writ petition is seeking a prayer of quo warranto has been filed at the behest of someone else who must be having his or her grievance against a person who is said to have held the public office. It is true that the writ court does not question the locus standi of the petitioner, but the eyes cannot be closed in examining the bona fide of the petitioner. Para 11, my lords. By means, para 11 on the point, my lords. By means of this petition, the appointment of opposite party number 3 on the basis of associate professor and professor has been impeached. If the appointment promotion of the opposite party number 3 on the post of associate professor and professor was illegal at the point of time, the writ in nature of certiorari may be invoked by the aggrieved person, but such relief may not be granted in the garb of writ of quo warranto by a busybody. A writ of quo warranto may not be a substitute of a writ of certiorari. It is a trite law that the writ of quo warranto may be refused where it is an outcome of malice or ill will. It is also trite law the only person who comes to the court with bona fides and public interest can have locus. Let's realize.
Learned senior advocate, Mr. Arun. What's the initial?
Respondent, my lords, 1 point, my lords, respondent number 3 is my former chairman, my lords. In fact, referred and recommended my promotion and
For the
appointment.
Petitioner. Who appears learned additional government advocates with the Nilofer for correspondence of one state.
I appear for the university, my lords. In this matter, I appear for the university.
Learned advocate, you are for?
Are for respondent number 5, my lords.
I am for respondent number 2, my lords.
2. You are for number 1?
Yeah.
1. 1. So and so for number 2. And learned advocate, Mr.
Lakshmikant.
Lakshmikant for number 5.
Respondent.
From at length. Learned advocate parties stated that they argued the petition finally. They further stated that the readings are complete and no further are required to be added or supplemented. Reserved for judgment.
My lords, merits, I have some say, the merits of the matter.
Please.
Okay.
There, my lords, I got 2 submissions, my lords.
Regarding maintainability, my lords,
Lords, I got 2 short submissions.
Yes.
Lords, the petitioner number 3 here in my lords was working in the very university. He was working with the, in the sense, my lords, the respondent number 5, petition number 3, my lords. In same department there he was working and he was heading, my lords. So, my lords, there seems to be some kind of vengeance.
This is all peripheral.
There, my
Go
lords.
to the.
No,
And
he's
my lords,
46.
and one
He-
more submission.
he is
lords.
retired
This
now.
one-
He is interested in the department being run properly, my lords.
My
It
lords,
is
one-
not as if he is a busybody coming before this honorable court and filing some petition and seeking for some order.
Only
my-
one submission.
My lords, 2 submissions in this matter in view of this judgment cited by them. Your lordship may kindly see the first judgment, my lords, para 8 and 9. That was not an issue before the honorable Supreme Court. The statutory rules were not pressed into service. Your lordship may kindly turn to page 18 in the constitution bench judgment in Govind Rao, which was taken up from Karnataka in the previous judgment,
Paragraph 9.
para 8 and 9.
We have seen this.
2 judgments. The statutory rules were not placed before the High Court for deciding. Only the advertisement, what was in the advertisement, it was pleaded. The Supreme Court said, you are not placed the statutory rules. Therefore, we are not interfering in the matter. That is a different context, para 8 and 9. And in the next judgment of Lordship, this Deepak Mishra, the Lordship may kindly see the judgment at page 23. 2 paragraphs in the judgment, para 21 and 22.
Page 23.
23, para 21 and 22.
Deepak Mishra is which Deepak?
Yes, yes. The page 23, my lords. Page 23, in the compilation of judgment filed by my learned friend. He read that judgment, para 8 he read. Your lordship may kindly see para 20 and 21. In the same judgment, 21 and 22 at page 36. It starts at 23, my lords. I'm sorry, my lords.
No, name Deepak Mishra doesn't, where is that?
It is there, my lords, page 23. His lordship has authored that judgment. I'm sorry. Para 21 may kindly be seen. Yes, I'm sorry.
I am sorry.
Yeah.
Yes.
In that para 21 may kindly be seen.
Only one
I
submission.
missed to get his party's name, yes.
That's the,
Paragraph
UGC was.
21,
One.
2 paragraphs, my lords. Very relevant to the present matter, in so far as maintainability is concerned.
Yes.
From the aforesaid exposition of law, it is clear as noonday that the jurisdiction of High Court while issuing a writ of quo warranto is a limited one, can only be issued when the person holding the public office lacks the eligibility criteria or when the appointment is contrary to statutory rules. That apart, the concept of locus standi, which is strictly applicable to service jurisprudence for the purpose of canvassing the legality or correctness of the action, should not be allowed to have any entry. For such allowance is likely to exceed the limits of quo warranto, which is impermissible. The basic purpose of a review of quo warranto is to confer jurisdiction in the constitutional court. See that a public office is not held by a usurper without any legal authority. Next paragraph, my lords. While dealing with the writ of quo warranto, another aspect has to be kept in view. Sometimes a contention is raised pertaining to doctrine of delay and latches in filing a writ of quo warranto. There is a difference pertaining to a personal interest or individual interest on the one hand, and interest by a citizen as a relator to the court on the other. The principle of so and so. Now, I'll only read two paragraphs in Gambhirdan for maintainability. Last submissions. My lords may kindly turn to, in Gambhirdan's case, para 16. Para 16. When a writ of quo warranto, when a writ of quo live has to be dealt with by this court in Rajesh Savasti was so and so. In para 19, it has been observed and dealt as under only one sentence. I'll read. A writ of quo warranto will lie when the appointment is made contrary to statutory provisions. Then in para 17, my lords. In Armed Forces Medical Association's Union of India, it has been observed by this court that strict rules of locus standi are relaxed to some extent in a quo warranto proceedings. It is further observed in the said decision that broadly stated the writ quo warranto proceedings affords a judicial remedy by which any person who holds an independent substantive public office or franchise or liberty is called upon to show by what right he holds the said office, franchise or liberty, so that his title to it may be duly determined, and in case finding is that holder of the office has no title, he would be ousted from that office by a judicial order. It is further observed that in other words, procedure of quo warranto gives the judiciary a weapon to control the executive of making appointments to public law and to protect citizens from being deprived of public office to which they have a right. Next paragraph, my lords. That as per the law laid down in a catena of decisions, the jurisdiction of a court to issue a record is limited one which can only be issued so and so. That is repeated. I will not read that. My lords, may kindly turn to para 20, my lords. UGC regulations they bring in. Now the next question which is posed for consideration of this court is whether the appointment of respondent number 4 as a vice chancellor of so and so university can be said to be contrary to any statutory provisions, whether it can be said that respondent number 4 fulfills the eligibility criteria for the post of vice chancellor. While examining the aforesaid issues, the relevant provisions of UGC regulations 2010 enacted in exercise of power conferred by the classes E and G of section 21 of section 26 of the University Grants Commission Act and relevant provision of so and so are required to be referred. UGC Act was enacted to make provisions for coordination and determination of standards in universities and for that purpose to establish a University Grants Commission. Section 12 deals with functions of commission. I will not read that. My lords may kindly turn to page para 20.3. For the appointment, same regulations, my lords, for the appointment and career advancement of teachers, under that is coming, this respondent number 5 is coming. In the universities and institutions affiliated to it, UGC by regulation dated so and so enacted the University Grants Commission regulation 2000. However, in the said regulation of no qualification or prescribed to the post of pro chancellor or vice chancellor. My lords may kindly skip to para 23. In view of the aforesaid letter dated so and so issued by the government of India, they prescribe the conditions. Then your lordship may kindly skip to para 26. Thus, UGC regulations, inter-alia prescribed in regulation 7.3 is that a person shall have 10 years of teaching work experience as a professor in a university system. It provides for constitution of such committee consisting of a nominee of vice chancellor, a nominee of the chairman of the UGC, a nominee of the syndicate, executive council of the council, and such committee has to recommend the names of the so and so. Then I will not read the further paragraphs. Your lordship may kindly skip to para 41. The communication was made by UGC to the Excellency. Para 42, the governor directed the university to comply. My lords may kindly skip to para 44. In the context I am reading, I'm sorry, my lords, I'm skipping the para 44. Thus, we find The appointment of respondent number 4 is contrary to UGC regulations 2018. Also, respondent number 4 has been appointed by a search committee not constituted. My lords, kindly note this. In this matter also, search committee is not constituted as per UGC regulations of 2016 and 18. We are not as per UGC regulations 2018. Moreover, respondent does not fulfill the eligibility criteria as per UGC regulations, namely having 10 years of teaching experience as a professor. Your lordship may kindly come to para 48. I'll read it for the cost of repetition, my lords. Para 47. We have referred to the official letter dated so and so. Letter of the Secretary of the UGC dated 11/8/2014 to His Excellency the Governor of Gujarat, informing about the regulation titled Minimum Qualification for Appointment of Teachers and Other Academic Universities and Colleges and Measures for Maintenance of Standards in Higher Education, has also been extracted above in the said letter. It has been clearly stated the UGC has prescribed minimum qualification for appointment of vice chancellor. Therefore, such an appointment must be accordance with the provisions laid down in the aforementioned regulations of UGC. It is clear that the respondent state of Gujarat has failed to take note of the communication to UGC, and instead the respondent university has left it to the sweet will of the search committee to prescribe eligibility criteria for the appointment of the vice chancellor university. Well, as last sentence in that line, only last sentence in that line. The eligibility criteria once fixed by the UGC under its regulations would, in our view, apply to all universities.
We have noted that the.
Please, my lords, I'm sorry.
Now what remains?
Only one submission, my lords. My lords, in this very matter, my lords, on 5/8/2021, this honorable.
Has to end, we will end. We are ending, yes, next.
My lords, this is last, only one sentence more. My lords, this honorable court had directed the UGC, my lords, to look into the record and take a clear stand on the matter. My lords, the report has been filed by the UGC.
They have not taken a clear stand. Para 11, they have not disputed. Para 11, they say they don't know plagiarism. Clear stand of the UGC in dereliction of what directions were issued by this honorable court. Very sad, my lords. UGC is behaving like this in these matters.
They are going to take a clear stand, right or wrong?
My lords,
UGC
only one annexure, my lords, governor's communication. I'm sorry, my lords, I'm seeking your lordship's indulgence. Annexure page 221, my lords. Your lordship, only one annexure for a moment. In view of the nature of the matter, I'm sorry, I'm requesting the court.
But now you continue up to one.
No, only 1 minute, my lords.
No, we'll not give you up.
No, only 1 minute, my lords, I'll take. I'll only show this.
Yes.
If this is violated, page 221, what the Supreme Court was referring to governor's communication of UGC to the Excellency, the Chancellor, page 221, annexure P. Annexure P, my lords, page 221. Public notice on academic integrity. This is not the thing the UGC sent to all chancellors. 14 June 2019. In this, plagiarism is a very serious issue. Action has to be taken to deal with it in a proper manner. This is the public notice to all the universities. This is what the Supreme Court was taking cognizance of, my lords.
Yes,
I'm sorry.
It itself has said there is no irregularity.
No,
or
that
illegality.
is not fair, my lords. UGC is not
Definitely.
fair to the court.
Well
Court
said.
clearly said, take a clear stand. UGC has said it will not dispute para 11. Kindly see the objections of university UGC. UGC objections.
2020.
Only one objection of the UGC. How UGC working in this country? Your lordship make kindly one paragraph. Contradicts it in one paragraph. Para 14 of the UGC objections, my lords. Respondent number 4 subjections filed on 12/12/2024.
Also praying spirit of warrant against UGC.
My lords, academic integrity in the university. I have no forum. Please, my lords.
No, 24.
I'm sorry.
No, welcome. All are welcome. Next.
24 urgent, number 25. To S.Y. Shivali.
Lord, so far as not my case is concerned, I will not submit only few facts about my case is concerned. Rest legal not contention not I lot of not in council.
Mine is 25, 1.123 are my matters, ma'am.
And in 25-1, my lease is going to expire day after tomorrow. That's a matter is placed before my law hands.
Several matters where the lease has been cancelled, my lord. There's a cancellation order. They have impugned the cancellation orders. my
First
lord.
matter, you are challenging validity of which rule?
Lord, in all the matters, my lord, there is challenge to entry 33, my lord, of the schedule to KMCC or
So
rules, my
it's
lord.
not value.
I am not challenged the entire entry.
Entry.
Only the portion which is passed without the authority of law, that's only I have challenged. Entry 33 of KMMC rules may kindly be seen, my lord. I may kindly be permitted to read. I had already extracted also in my writ petition at page number.
We'll take up after recess. After recess, only 3 minutes are left. After recess, we'll take.
Please. Please, my lord.
You're also pressing prayer.
Please.
I filed the complaints affidavit without serving the opposite side. I'll serve it, I sent a text message to him that I'll serve it to you today and I'll make a mention at 1:30. He has not replied so far. May I seek for 2 weeks accommodation? In the meantime, I'll serve a copy of it.
Take the, you give some.
My lord,
Serial number 60.
Leave. May I please mention, my lord, serial number 79. I filed a memo seeking withdrawal. Seeking withdrawal, my lord.
79.
Yes.
Learned advocate, Mr. Your senior learned advocate Arjun Rao.
Yes.
For the complainant. Because the memo for withdrawal dated 28/12/24, which figures on record, which is signed by the advocate, signed by the complainant as well as learned advocate of the complainant. It is stated in the memo that the parties have mutually agreed to arrive at certain conditions to resolve the dispute, and that the memorandum of understanding dated 28 November 24 is also executed. In light thereof, prayer is made to permit the withdrawal of the contempt proceedings. Permission is granted, the contempt petition stands dismissed as withdrawn.
Serial number 69, Your Lordship. Serial number 69, Your Lordship. Your Lordship, I request 2 weeks' time for compliance of office objections, Your Lordship.
2 weeks' time is granted to comply with the office of the failing which the petition shall stand disposed of, shall stand dismissed without reference to or order of the court. Yes.
Serial number 43, my lord.
43.
Sample court, this bench is disabled. Matter.
Pardon?
Into order. Page number 11.
All 42 and 43. Without asking, you can not to be placed before the bench where one of us integrate honorable Mr. Mayaru, secretary is a member.
I have also filed another writ appeal.
42,
containing the same
43 also same.
common order, my lord. Writ
Pardon?
appeal 1364. Same order, maybe. Maybe
Unless it
corrected.
is there, we can, once it is listed, we'll.
Serial number 42 also. Serial number 42.
42. It is already passed, so
Yes,
same one.
Well, matter still number 30 to appear for the accused. So the order of this honorable court is complied with. Complaint counsel is
Not the
also.
complaint is my lord. Partially they complained. It may be closed with the liberty for me to, they are not paid the interest for the delayed period.
Because
of-
the order passed with the Leonard single judge, it's complied.
My writ petition is allowed in entirety, my lord.
Learned single judge provided for interest,
No, my lord.
No, my prayer is there. My second
order.
prayer is very,
prayer in.
no, that's why my lord, let it be closed with the liberty for me to urge whatever the.
If there is no providence in the order.
Yes, no, there's no order.
My writ petition is allowed in entirety, my lord.
Serial number 39.
32, my lord.
32. 32 contempt petition 800 of 24. Learned advocate for the respondent, Mr. P. Anand,
Yes, ma'am.
stated that the
I filed compliance affidavit also, ma'am.
order is complied with and the amount indicated in paragraph 14 of the order
It's paid.
Learned single dated 29th November 23 is refunded.
Yes,
to the
ma'am, it's
petitioner.
paid.
Full stop. The factum of refund and of the amount and the receipt thereof could not be disputed by, is not disputed by learned advocate Mr. Udaya Kumar RL for the complaint. In aforesaid view, since the order and the direction is complied with, nothing survives in the present contempt petition, it is disposed of accordingly. Full stop. Learned advocate petitioners at this stage submitted that the complainant has a claim for interest, comma. It is, the interest is not the part of the directions of learned single judge, therefore it is not within the domain of this jurisdiction.
God bless.
Contempt petition is dismissed as not survived.
Number 25.
Yes.
Lord, so far as my writ petition serial number 25 is concerned,
My submission would be, my lords, my submission would be that my lease is going to only about this.
in all cases, similar issue is in.
Similar.
No, but
Well,
the
validity
lease
is
would be
concerned.
applicant, I am leaseholder, my lord. That makes a lot of difference. That is differentiating feature.
So far as question.
All
of
the
law is
matter, my
concerned,
lord, the constitutional validity, my lord, has been in challenge regarding entry 33, my lord. Individual cases, my lord, orders have been passed rejecting the license, my lord, against which revision would lie in any case, my lord. Remedy is there of revision. Revision 53 is a revision,
I
my lord.
beg to differ.
But for,
with the
except for the
submission, my
challenge
lord.
to the validity, otherwise it would have been revision.
No, this is not, this is erroneous submission. For the simple reason that for the last 3 years, I am before my lords in this court. And earlier occasion, I succeeded, and this honorable court directed them to consider my application. Having once granted me the lease, license in private pata land, it is valid initially for a period of 3.
Same prayer, my lord.
No, only validity is only a portion of the entry 33, my lords. But I think in the meantime, I am willing to pay. The question is about the rate of royalty, my lord. I am willing to pay double the rate of royalty. Whichever is they are going to demand, I am willing to pay, subject to the results of this writ petition, my lord. I may be allowed to operate. And if they are still insisting, I am willing to make a one-time deposit of amount that is this honorable court is going to fix. Subject to the results of the writ petition, I am abiding by that. Whichever way, according to them, it is 80 rupees in the first instance. Later on, it is amended to 160 rupees. Even that amount I am willing to pay. I will go on paying that 160 rupees for extracted metric ton of mineral.
My lord, the difficulty is, my lord, the rejection, my lord, in all these cases for the reason that the mineral found is a major mineral, my lord. It is an aluminous laterite, my lord. The percentage in the samples that have been extracted, my lord, the percentage exceeds 20%, my lord. If it is less than the threshold of 20%, my lord, it would qualify to be a laterite. Lordship may kindly see page 146 is the notification issued by the Government of India, my lord. Annexure N, page 146. Serial number 2 may kindly be seen, my lord. This is the threshold for bauxite, my lord. There are 2 sub-items there, my lord. Page 146. Serial number 2 may kindly be seen, my lord. For aluminous laterite, my lord, AL2O3, 20% minimum. Moment it reaches the threshold of 20%, my lord, it qualifies to be a major mineral, my lord, over which the state government doesn't have powers to regulate. Therefore, my lord, the rejection orders have been passed in this case because they have crossed that. We don't have powers to regulate, even license we can't give at this point of time. That is the reason for rejection, my lord.
But my submission is that notification has already been overruled and fresh notification has been issued. It is produced at page number 144 at Annexure M. Blatantly, they are making an incorrect submission, my lord, just to suit.
Yeah, even that is,
Augment
20% is threshold even there.
No, you please go through. Threshold value, I may kindly be permitted to read. Serial number 2 of the notification says about the bauxite. Sub 1, for aluminous laterite, AL2O3, 20% minimum. That is independent. Number 2, for bauxite, AL so-and-so, 30% minimum and SiO2 total 7%. Because even if whether the bauxite content is 20%, 30%, 50%, if the silica content is more than 7%, it cannot be called as bauxite.
Percentage is same, my lord. Percentage is same. It
The
qualifies to be major.
proportionates are different because in 2015, this laterite has been declared as a minor mineral. That's why the next notification is important.
Replace have been filed in all matters.
It has been filed and even the examination reports, the testing reports, everything is placed on record, my lords. And in all the cases, silica content is more than 20%, 25%, 30% as the case is cannot be used for aluminum industry for bauxite. By stretch of imagination, they cannot. So they don't have legislative competence to the notification itself is issued under rules of mineral concession development rules, which is major mineral. It cannot be considered in minor mineral. This basic aspect, the state government is not in a position to differentiate, my lords. A very sorry state of affair that we are facing here.
Heard so and so in the present petition filed under Article 226 of the Constitution, following prayers are advanced. The bracketed portion. Roman small one. Red bracket. Then Roman small 2. Roman small 3. Any of the challenge to the virus of the provisions of the Mines and Minerals Integrated Development and Regulation Act 1957 and the prayer to declare newly inserted entry number 33 into small 1 and small 2 of Schedule 2 of Rule 36 into bracket 1 of Karnataka Minor Mineral Concession Rules 1994, the petition requires final hearing, therefore rule returnable on which date? March 18th March.
But in this meantime, some protection, my lord.
Learned additional government advocate accepts the notice.
Please, my lord, we have accepted the notice and filed our response also.
Even the IBM people have also filed their statement. At the maximum, I can say that instead of cutting short the time, I can adopt their contention, my lord. They very categorically and vociferously state that it is a minor mineral and wherein threshold value cannot be fixed. It is only in respect of major mineral, threshold value can be fixed.
So then A18786 of 2022. Or learned advocate Mr. So-and-so petition. Same. The prayers in this petition. Are identical and similar to one made in the petition number 4834 of 2022, in which rule is issued and the petition is listed for final hearing on 18th March. The same course
18th March
has to be adopted in the present petition in view that the controversy is similar. Therefore, rule returnable 18th March to be listed with state petition number 4834 of 23.
My only submission, again, my lord repeated, that I may be allowed to operate by making double the royalty that is claimed by them. They are not put to any loss. Whereas my petitioners are, I think they will be very much.
Not within our jurisdiction, my lord. Moment it exceeds the 20%, my lord, we don't regulate it, my lord. It becomes a major mineral basically.
So if it
Question
is
has
a
to be
major
addressed, my
mineral,
lord.
according to them, how can you regulate here?
On the scale. Then 4, 2, 3, 5.
Critical, my lords.
Hmm.
But the last third one is, I think that is, that doesn't survive.
Which is third one?
That's number is 1 minute, my lord. 4373.
So 427, 4235.
Yes,
same
just
one.
2 matters will survive.
Rule written. And which will not survive like
Writ petition number 4373.
4373
Of
of
2023, my lord.
2020. Learned advocate for the petitioner, Mr. So and so and so states that the present petition does not survive for any further consideration. Therefore, the petitioner is not interested in prosecuting the petition. Dismissed as, in view of the statement, dismissed as not surviving.
Please, my lords.
In view of the statement, the petition is dismissed as not.
230 matters, cell number 80.
Appearing for accused Lord. Lord, in this we have complied with the order and I am filing the compliance affidavit, Lord. I did not receive the copy, Your Lordship.
First, give to your learned friend. This practice is not wrong. This practice is wrong here. First, you give to learned friend, then give to the court.
Yes.
So you reinstated with whole.
Given, Lords. I have served the copy.
No, he is reinstated.
Yes, Lords.
All benefit.
Instead, before they are filing contempt itself, Lords, they ask for paying benefits, Lords. We have paid that also.
All benefits are.
Yes, Lords.
Lord, may I go through this statement and make my submission, my lord? Can it be taken up tomorrow?
Let us, we accept the state. Complaint has been reinstated.
Yes, your lordship.
Benefits, along
Here-
with the benefits.
Yes, Lord.
The total amount paid, they have not mentioned. My client is
They have
entitled to
mentioned the
receive.
months and the dates also, Lords. With, along with check number itself.
Your lordship, total amount of 3,45,000, the complainant is entitled to receive. But from the statement which they have produced, I'm not able to see it is that much of amount.
Lords, since he is appointed as a temporary data clerk entry, he have not attended the office since February 2023 to September 2023, Lords, that we can't pay the benefits for that, Lords, since he was not a permanent employee of the Panchayat.
The direction of learned single judge was to reinstate the petitioner and with reinstate the petitioner with
All consequential benefits.
sequential service benefits. Full stop. In response to the contempt petition filed, alleging non-compliance of the above direction, today when the petition comes up for consideration, learned advocate Ms. So files compliance affidavit, it is 16/1/25, in which it is stated that the complainant has been reinstated in service along with the benefits in accordance with law. Pulls to the statement showing the checks paid towards the salary benefits is also produced. Full stop. The reinstatement and the payment of amount as above marks substantial compliance. The direction of learned single judge. Full stop. The contempt petition is not required to be continued any further. It is disposed of accordingly. full stop, learned advocate, Miss so and so for the complainant would submit that the amount paid not according to the calculation of the petitioner. Full stop, any calculation dispute may be resolved by the petitioner by making representation to the competent authority. Full stop. In the event the grievance still subsists, the petitioner will have a remedy open to be prosecuted any other than the contempt petition disposed of it.
Lordship, one submission, Your Lordship. Just half an hour back, I've called my client and I was told that no amount is paid so far. That is why I'm making this submission, Your Lordship.
Check
They
details
have
of
only,
details of checks are there, madam. Not just bad statement. See the,
Here we
see
have
the,
the sign of signature of,
therefore it is
person.
disclosed. Checks are paid to you. In your name, must be in your name. Bound to be in your name.
Lords, this is the original copy where the complainant has signed that receiving the amount.
All 15,000, 7,500, 15,000. He was daily rated work.
Lords,
Daily rated workman.
no, he is temporary employed workman, not a permanent employee of the Punjab. Jai Lakshmi. It's in Kannada. Signature of the complainant, Lords, that she has received the amount.
Signature last.
Yes, Lords. Since I have filed the check number, so I have not produced this.
Yeah. So you move and take out proceedings if you are entitled to more.
Okay.
Number 81. Shani Rudana.
My lord, I beg to appear, my lord, if your lordships can see me on the screen. I beg to appear, my lord, for the petitioner.
Yes.
In this writ petition, my lord, this is for final hearing.
This is for final hearing.
This is number 81. Shani Rudana.
Yes, my lord, I appear in 81.
So what is the interim order granted?
My lord, there is an interim order granted in regard to, my lord, an order which was impugned in the petition asking me to stop mining. There was an order granted to us, my lord, by the Supreme Court. Then the Supreme Court asked us to, my lord, approach the High Court. And your lordships continued the order of the Supreme Court.
Order the High Court.
We may set down a date for hearing, Mr. Rohtak.
Yeah, my lord, if your lordships have time today, I can do it today. If your lordships, my lord, are inclined to keep it another day, Would your lordship keep it, my lord, on the last Thursday of the month? Thursday is the easiest day, my lord. I would like to come there and argue it, my lord.
That is better, Mr. Varun.
All right, my lord, Wednesday or Thursday, the last Wednesday or Thursday, my lord, will be.
Last Wednesday is holiday, my lord, Republic.
No, any
Sorry?
convenient to the council from
Outside.
Delhi and yourself all. We'll fix a date so that some time can be devoted.
30th,
Effective.
29th or 30th is fine.
30th should be okay.
30th,
If it is okay.
So 30th, my lord, 30th.
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 Only one request, my lord.
Yes.
If it is possible, my lord, in the pre-lunch session, if it is possible.
Pre-lunch session.
Because, my lord, going back to Delhi becomes difficult, my lord, if the. But anyway, my lord, I will make myself available, subject to lordship's pleasure and the board available.
But in courtroom, we will get fogless atmosphere.
So I will come, my lord, on 30th. Your lordship may take it up.
No fog here. Anyway, we'll try to accommodate you in the first half.
My lord, the interim order to continue. Your lordship may try to take it in the first half.
30th.
I will be in court, my lord.
30th January.
I am very grateful.
30th January, interim order granted earlier shall continue.
I am very grateful.
Till the next date.
Great.
Number 82. The Dhananjay CP.
Today's matter where I filed a memo, my lord, bringing to my lord's notice the clearance of the encroachment of a lake area.
On the last occasion, learned advocate for the petitioner was not present. Today, when the petition came up for consideration, learned advocate for the petition is again absent. The last chance to be listed at 2:30 on 22nd January.
Cell number 83. The Raghavendra Ji Gayatri.
Pay for the petition. Deemed conversion. Deemed conversion under 95(9).
Covered some.
Covered.
Yes, my lord. So which is the one?
Bring out this. Bring out the copy. All right.
Obliged.
Obliged.
Number 84.
This was 83.
Paying for the respondent number 5 and 6.
83.
83. 84. Mr. Srikanth.
Regarding payment of note salary. Matter was listed, my lords, on the other day, my lords, I brought to your lordship's notice, my lord, that I sought for salary, my lords, in accordance with rules. It was contended by other side that the rules are held to be unconstitutional, but was stated by, my lord, the Honorable Supreme Court. However, the learned single judge says, my lords, it cannot be applied since the matter is pending before the Honorable Supreme Court, in spite of there being an interim order. Page number 36, my lords, para 5.
my lords.
So by virtue of, by virtue of Supreme Court order, you are entitled.
Lords, by the order of the division bench of this honorable court, the rule which is in my favor is held to be unconstitutional.
It is, now it is.
My lord, state by the honorable Supreme.
I'm yet to receive instructions from my respondent, my lord. Respondent number 5, my lord. His mother passed away on the last date of hearing. I was
Where
yet
is-
to, yesterday I had asked for the, the counsel for a copy of the petition, my lords. It was not shared to me.
Lords, I have one more set of papers.
Where is that order of Supreme Court?
Sorry, my lords, right now I don't think I have a copy. but
Next time you bring it.
2 weeks' time.
Why?
My lords, the respondent number 5 is, he has another 10 days of rituals to complete, my lords. I'm yet to seek instructions from respondent number 5.
Earlier you were saying some different reason.
No, that day, my lords, senior was in, senior was not there that day. He has given me the liberty to argue in this matter, but respondent number 5's mother passed on the same day of hearing. So I can give an affidavit on that regard, my lords. He passed and he's
No, we
completing
don't
his.
want- We don't want any affidavit. But then it is for, you are the person to argue, not number 5.
Yes, he had some instruction to give. 2 weeks, ma'am. Can you please, my lords?
Not 2 weeks, we'll give you, 31st we'll give, as good as 2 weeks.
Most of
31st.
much of this.
In the meanwhile, I'll place it on record. In the meanwhile, I'll place the interim
Bring
order. on
that
record.
order.
Please,
Entire judgment is stayed.
yes,
Seal number 85, Mr. Satish K.
I'm appearing for appellant, my lord.
Why it is kept at 2:30?
My lord. Very short point, my lord.
No, short.
I'm
note
only
is no
agreed by the part of the order, my lord.
Hmm?
Page number 51. I'm only agreed by the part of the order.
Yes.
Page number 51, my lord. The honorable single judge has allowed the writ petition and imposed the cost on the appellant, my lord. The appellant was working as district officer at the relevant point of time.
Page?
Page 51, my lord. Para 15.
Post kahan hai? Where is-
Roman number 3 to 5, my lord. I'm agreed by this. Three to 5.
Validity certificate for what?
That has been issued, my lord.
For regarding?
Caste certificate.
Regarding caste certificate, my lord.
Caste
Caste certificate, my lord. That has been issued subsequent to the order.
Pursuant to this order, my lord, we have issued caste certificate, my lord, and she has been appointed and she is working.
Where is the prayer in the main petition?
Page 24, my lord, page 24.
No, prayer.
No, in the writ petition, 67.
Issue the validity
66, my lord, 66 pages.
Now, this 3 and 4 travels beyond the prayer. Salary so paid shall be recorded.
Please, my lord.
Yes, my lord.
That we may set aside 3 and 4.
3, 4, 5, my lords, and 5.
What is 5?
Report of the action taken shall be filed before the registry of this court.
My lord, we are sailing with the appellants here, my lord. But the writ petitioners have to come on record, my lord, because this is a case where the order is for pay the compensation and
The
recover from
present
the
appeal
officer.
is filed. Polling in question. Judgment and order dated 2nd February 23, passed by a single judge. Disposing of writ petition, more particularly assailing the operative directions in paragraph 15, Roman small 3 to 15, Roman small 5. Full stop. The operative portion, paragraph. Reads as in that, then quote entire paragraph 15. 51. Paragraph. The main petition was filed by the
Respondent number 1.
respondent number
1. Writ petition was filed by the respondent number 1.
1. Wherein only prayer was made was to direct respondent number 1 authority to issue validity certificate in relation to the caste
Please, ma'am.
of the petitioner. The other prayer was for direction to consider the representation of the petitioner in that regard. Full stop. Learned a single judge allowed the petition, directing respondent 2 to issue validity certificate to the petitioner. It is stated in course of the hearing of the appeal that the validity certificate is already issued
Issued,
to
madam.
the petitioner.
On 4.
Therefore, nothing survives in that regard. Paragraph. Even otherwise, the challenge in this appeal by the appellant is confined to the directions number small Roman 3 and small Roman 4, 3, 4, and 5, whereby the petitioner whereby it is directed to pay to the petitioner compensation of 3 months' salary. It is further directed to recover the salary to be so paid from the officer concerned. Review was dismissed.
Review was dismissed. My lord, I was not personally party before the honorable single judge in writ petition, my lord. However, there is an order against on my personal capacity. So I have preferred review.
Leave to appeal is granted.
Please,
Leave to appeal is granted since you are not a party.
no, my lord.
So how can you file it? There is no
There
application.
is application, my lord, but
There is an application leave to appeal.
there is an application, my lord. There is no order on that application.
Where is the application for leave to appeal?
Page 289, my lord.
289.
Please, my lord. 289 of the writ appeal, my lord.
Grant leave to appeal, yes. Who are you?
I am the district officer, my lord.
The very person from whose pocket the salary is.
Please, my lord. Please, my lord. This writ appeal is on my personal capacity, my lord.
Whatever.
The salary so shall be paid recovered from the hands of the officer so identified, my lord. It's fine.
Better to. So we'll issue notice.
Notice to respond number 1, my lord. They are.
Notice to respond number 1. Notice the respondents returnable on. So notice in leave to appeal application as well as in appeal, as also in the delay conduct.
Please.
Returnable on. We'll say that directly, sir, by hand delivery will serve.
Answer it.
For you it is. You will serve by hand delivery.
Please, my lord. Hand summons may be ordered. In addition to court notice, my lord.
On 29th January. Learned government advocate, Mr. Harish, accepts notice. We have
On number 225.
this one, 2.
225, my lord.
225. The rest of the respondents will be served, for which the service by hand delivery is permitted. Looking to the nature of challenge, nature and the extent of challenge. Put up 230 on 29th of January. With an observation that even after service of notice, the respondent does not appear on the next day. The court may take up the proceedings for passing appropriate orders in accordance with law.
At 2:30, my lord. At 2:30, my lord.
कितनी बार? 2 बार 2
Yes.
twice.
Great.
To be kept twice at 2:30.
Great, sir.
So number 86. P.M.
Earlier round,
This that show cause notice.
yes, show cause notice.
Right.
One of the contentions which was specifically.
I could not go through.
I'm
Now,
sorry.
You show that it is on
Please,
merits.
please, no. If lordships are to see the earlier order passed by the authority, the earlier order is passed at page 59, 60.
59.
59.
Oh.
But 59, if lordships are to see, the first respondent has stated in their argument that Amaravati Enterprises, the partnership firm, had retired from the partnership before the bank elections. Additionally, the branch manager of I'm sorry, page 59, bro. I'm sorry. After the first sentence.
First respondent has
Yes,
stated.
this is my case was that I had retired from the firm which had availed the loan and which had turned into a defaulter. This was a specific contention. First respondent had stated in their argument that Amaravati Enterprises, the partnership firm. But not only this, we had produced the reconstitution deed. We had produced the deed of retirement. Considering all these aspects, petition came to be rejected, affirmed by this honorable court indirectly though. The question of again issuing the show cause notice on the same cause of action, now saying for a subsequent year, does not arise. In fact, I must bring to lordship's notice. This question cannot be repeatedly agitated and re-agitated again and again. The court also held, of course, that the petition itself was not maintainable because it indirectly seems to challenge the election of the petitioner, which is for which a dispute should be raised under section 70 of the Cooperative Societies Act, relying upon a division bench judgment of this honorable court. Now, obviously, the matter was taken up before the appellate authority. Appellate authority granted an interim order, as against which we moved this honorable court dismissed the appeal. But they should have challenged this order. The persons concerned ought to have challenged this order if they found any infirmity. Second notice is at page 82.
No, you said that this page 60 order was confirmed by the.
I'm sorry.
This order at page 60.
Yes.
Was confirmed by this court.
Order of this court, they challenged it in an appeal. The appellate authority granted an interim order.
as against which, my lord, I filed a writ petition before this honorable court. This honorable court dismissed the appeal, holding that it is not maintainable. But that order of this honorable court is at page 71, dated 23rd January 2024. But all these facts were before this honorable court.
So page 71 order, 77 order.
Or reaffirms the order passed by the authority concerned, rejecting their claim for disqualification.
Rejecting their claim of your disqualification.
Yes, that's
You are Ashwastha.
Ashwath. I am Ashwath.
And that is upheld by this court.
This honorable court. Now, my lords, the same, my lords, it is repeated, show cause notice.
Where is that show cause?
The present show cause notice, lordships will get it at page 82. There is no reference to the order earlier proceedings. But if lords, they refer to two loan accounts. It is the same accounts.
And where is the first notice?
Present show cause notice. First show cause notice, my lord, is page 50. Yes.
43.
43. That's correct. English translation. Page 43. Now, they seek to revisit it. The state's contention before the learned single judge is earlier petition was filed by one Satish. Now it is filed by the chief executive officer of another society. No evidence was produced at that time, is what they propose to say. But they say for the year 2022, 30th of April 2022 to 26th of September 2022, there is some outstanding dues shown in respect of this firm, which is subsequent in period. But the question is, the moot question is whether I was partner of the firm. I was not partner of the firm is my contention, which has been accepted by the original authority on the earlier proceedings. That cannot be revisited once again, is my respectful submission to lordships.
That is examined by the earlier authority.
Yes, my lord.
Where is the finding?
Yes, that finding, let's say, the original authority refers to it at, that is at page 59 again, I'll request. Sorry, page 59 again.
Page 59.
59, I'm sorry. He records the first respondent has stated in their argument that Amaravati Enterprises, the partnership firm, had retired from the partnership before the bank election. Now, after contending this next paragraph, he records for the aforesaid reasons, I reject the contention. And I had an occasion to look into the records. We had produced before the original authority earlier my deed of retirement, the fresh reconstitution of the partnership firm, which showed me that I was not partner of the firm. nothing prevented my lord from the aggrieved people to challenge this order if they had found any infirmity in this before the appropriate forum, either by filing a writ petition before this honorable court or raising a dispute under section 70 of the Cooperative Societies Act. Both such remedies were available. And also, lordships.
May I submit?
But I also, lordships, may kindly see page 113 for a moment. This document, it is this document, lords, which the original authority relies upon initially, annexure K, page 113. 113, lord. This is my retirement. 113 is my retirement. 114 is a partnership deed, which shows the petitioner no longer to have been part of the firm. These were documents which were part of the earlier order. But there are two decisions that I wanted to cite before your lordships. One is, lords, this Vipul Bhai's case, lordships are aware. In such similar situations, lord, the Honorable Supreme Court does declare that even in respect of administrative inquiries or quasi-judicial proceedings, you cannot, just because you have the power, you cannot repeatedly exercise the same, except for one exception. The exception being, if the proceedings have been quashed on an earlier occasion on the ground of violation of principles of natural justice. But may I request lordships to permit me to just cite this paragraph in Vipul Bhai. 2017, paragraph 36. Paragraph 36. This is one of those leading decisions not arising from Gujarat High Court. On para 36. Their lordships actually frame these questions. Any statutory power could be exercised from time to time on occasion as occasion requires. Such a principle is recognized by section 14 of the General Clauses Act 18. I'm sorry. Para 36. Yes. Any statutory power could be exercised from time to time as occasion requires. Such a principle is recognized by section 14 of the General Clauses Act 1897 and section 14 of the Gujarat General Clauses Act. Power conferred on the courts to adjudicate the rights and obligations of the parties is an exception to the principle. Now, lordships may kindly see this. The doctrine of res judicata and double jeopardy prohibit the repeated invocation of the jurisdiction of the civil courts or repeated attempts to prosecute a person on the same set of facts constituting an office, whether power conferred by a statute on a body other than a judicial body could be exercised repeatedly, or are there any legal limitations thereon? And if there are limitations thereon, what are they? Are the questions which require further examination. But for the purpose of this case, the questions need not be examined. It is already held by this court that where an order passed in exercise of a power conferred by statute is set aside on the ground that such an order was passed in breach of principles of natural justice, the power could once again be exercised by complying with the principles of natural justice. That is the only exception, lords, in my respectful submission, which could permit an authority to revisit the earlier set of proceedings. It is possible, but I must, with a great amount of humility, say it's possible that an earlier order may not be entirely correct. I'm not for a moment. But unless that has been challenged before the appropriate forum, that order becomes final, binding between the parties.
Yes.
Whirlpool Corporation, the last judgment, on the question of show cause notice, what they have. Again, this is very well settled position of law. I just need not. Well put. Pretty. Their lordships were examining this question about when the court under Article 226 could exercise its power, even against a show cause notice. That lordships will get it at para 14 and 15. I'm sorry. Oh, sorry. Extra copy. Please. I'm sorry. But para 15, may I draw lordship's attention to paragraph 15. Under Article 226 of the Constitution, the High One five. This is well settled. I'm just only bringing to lordship's notice. Under Article 226 of the Constitution, the High Court having regard to the facts of the case has discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed for the enforcement of any of the fundamental rights, or where there has been a violation of the principle of justice, principles of natural justice, or where the order or proceedings are wholly without jurisdiction or the virus of the act is challenged. Our case is a second show cause notice is certainly without jurisdiction. Therefore, Lord, petition would not have been rejected on the ground that it is against show cause notice.
My lords, my lords, 3 points I would like to make, my lords. There is absolutely no finding by the authority nor by the learned single judge that he is not a partner of the firm. The first notice, my lords, which came to be issued was on the ground that there was a complaint by a private party against the appellant. That matter was heard before the registrar, and in page 60, which was read out to my lords, there is absolutely no finding that he is not a partner. My lords, the registrar just records the submission of the first respondent. In the observation and in the finding, my lords, he just says 29C does not apply for pre-election allegation, and first petitioner being a defaulter after election, it cannot be considered. There is no finding that he is not a partner. My lords, this single registrar's order is challenged before the appellate authority. Appellate authority just passes an interim order staying the order of the registrar. That interim order is questioned before the learned single judge. If my lord turns to the learned single judge's order, my lords, very specifically, the discussion is only in para 6. Para 6, my lords, the discussion is not about whether the show cause notice is valid, whether the registrar's order is valid or not. The only discussion is whether there is any locus for this complainant to challenge it. My lords, para 74, para 6, my lords, of the learned single judge's order. May I read, my lords? Para 6. Para 6, may I read page 74. Learned counsel appearing for the petitioner would contend that the issue involved in the case, that is, whether the order under section 29 of the Act can be questioned by filing an appeal by a member of the society. That's all is considered by the learned single judge. Learned single judge does not in any way decide the merits of the case, nor does he decide whether he is a partner or not. My lords, my second contention before my lords is it is a fresh cause of action. Now the CEO gives a complaint on 2022. 2022, there is monies are not paid and he can be disqualified under 29C. There is a complaint given, my lords, based on the complaint and on the report by the bank that he is still a defaulter, we issue a show cause notice. My lords, may kindly see the order of the learned single judge which is questioned before my lords. The argument of the petitioner's appellants before my lords that he is no more a partner does not stand its legs because we have filed Form A by the registrar of firms that he still continues. That has been considered and no rejoinder is filed for that, and there is no denial also in the writ appeal to that effect. My lords, may kindly turn to page 21 of the impugned order. where the learned single judge records the specific finding that he is still a partner. Page 21, my lords. It is a submission of the state, my lords, 4.1. 4.1 may kindly be looked into. Page 21 of the impugned order, 4.1. My lords, it is clearly said, Mrs. Amravati Enterprise was a registered partnership firm under the provisions of Partnership Act 1932, and that in terms of the form number 1, which has been filed in relation thereto, the petitioner being shown as a partner. Subsequent to the same, there is no dissolution of the partnership, reconstitution of partnership, or a retirement deal which has been filed requiring the deletion of the name of the partner. They cannot file a notarized copy before my lords and say the firm is dissolved. They have to place it before the registrar of firms and he has to come out.
In the original folio, first time.
My respectful submission is he still continues to be a partner and he is still in default of the money. And my lords, it's a fresh cause of action, a fresh complaint for which a show cause notice is issued. My lords, my last submission before my lords would be, my lords may kindly turn to the writ appeal. Every ground, my lords, if my lords is the ground raised by the petitioners before my lords, page 10, it is not their case that the order of the learned single judge is bad for that show cause notice is second show cause notice on the same ground. My lords may kindly turn. Their grievance is the learned single judge records a finding on the merits of the case. Hence, they are denied to go and answer before the authorities. That is their case before my lords. My lords may kindly turn to page 10. The grounds of the petitioners in the writ appeal. May I read, my lords? It is submitted that while show cause notice was under challenge on any ground in support of such challenge, if it is found that on such ground show cause notice could not be interfered within the petition of Article 226 of the Constitution, normally court which required to be followed, this honorable court is driven to the parties to the authority by whom show cause notice was issued. They agree, we are ready to go back. Further, my lords, upon giving a liberty to raise such objections to the show cause notice, enable him to adjudicate on the same. But in the instant case, learned single judge records a finding on the merit of each of the question raised under the challenge, the correctness and the authority of show cause notice. Thereafter, the parties is given liberty to approach. Their only grievance is that the learned single judge recorded form number 1, in which he still continues as a partner and told them to go back and reply the show cause notice. That is the only grievance. It is not the same cause of action that has spent its time, and there is no finality arrived by the authority nor by the learned single judge in the earlier proceedings. Hence, my lords, they may answer all this before the authorities.
Yes.
Please, my lords. If my lord sees the writ appeal, their whole case is that the learned single judge has recorded the on merits, he has recorded a finding by which it will be difficult for them to explain before the authority that they are no more a partners. That is the only grievance. My lords, we produced form number 1. The learned single judge had to record it that he continues to be a partner, and it's a fresh cause of action. The CEO has given a complaint that even in 2022, he is a defaulter, and he continues to be a partner of the firm which owes money to the society. And under section 29C, my lords, he cannot continue to be a director. That is the bar. And if they want to continue, my lords, they can go and explain before the authority that they are not in default and they are not a partner. And there is no finding recorded as submitted by learned senior counsel, my lords. There is no finding at all by the authority nor by the learned single judge that he is not a partner. The only thing is he doesn't have a locus. The complainant is what is earlier recorded. My lords.
See, come to page number 83, 82 and 83.
I have 83 minutes.
This is the present show cause notice.
Please annex to G.
Allegation is Amaravati Enterprises,
Please, my lords.
a partnership firm, has borrowed loan from Tumkur Grain Merchants Cooperative Bank Limited,
Please.
and it has committed default.
Yes.
And petitioner is a partner of the said firm, continuing partner of the said firm. So is liable to be disqualified as per 29C. with regard to the same loan transaction, with regard to the same period, with regard to the same period,
Earlier period.
okay, earlier period, earlier notice was issued. That is annexure A.
Please,
Yeah, na?
my lords, it is annexure.
Page
See, I think.
43.
Uh,
Page 43.
Please, my lords, page 43, annexure B, my lords,
annexure B, yeah.
please.
And finding is given at annexure C. As you rightly pointed out, the judgment does not dwell into this. Judgment of this court does not dwell into this particular aspect.
Please, my lords,
But the relevant finding is in annexure C.
please.
Annexure C, what is the finding given?
My lords, still page 59, my lords, the registrar just records the pleadings of both petitioners and respondents. The finding is in page 60, 2 paragraphs. Since the petitioner failed to provide
59 and
59 last paragraph.
my lords,
First
59 is
paragraph.
what the argument of the first respondent he records.
Hmm.
He records the respondent's arguments, then he refers to the judgments, then page 60, my lords.
Hmm.
There are only 2 paragraphs. Since the petitioner failed to provide any evidence to support the claim of the first respondent being a defaulter after the election, and considering that section 29C does not apply to pre-election allegation, the request by the petitioner is not upheld. This is the finding. If my lord sees the latest show cause notice under challenge, my lords, kindly refer to the reference, my lords. There are 3 references. Annexure G, my lords, 80 is the Kannada language, 82 is the translated copy. There are 3 references, my lords. Annexure G, page 82, my lords will. My lords, first reference, letter from the President and Chief Executive Officer, Satanur Primary Cooperative Society, Mandya Taluk, dated 26/6/24. Second reference, my lords, letter from JRM, that is the Joint Registrar of this one. Third, my lords, they have obtained a report from the Assistant Registrar of Cooperative Society. So on all these counts, first they receive a complaint, then they also get a report from the bank, my lords. If my lord sees the show cause notice, the Tumkur Grain Merchant Bank submits, they take a report. And then this notice is given. My only submission before my lords is it is a fresh cause of action that has spent itself, where the locus of the party was decided. But here, my lords, the CEO, who is the authorized person of the bank, gives a complaint that so-and-so person who is the director of the federal bank, he is in default and he cannot continue.
All are not sought.
No, state has to take notice. They'll take that, please.
Notice.
3, 4, 5 are not so. Now, is it your contention that you are not a partner of?
I am not a partner and they cannot go on improvising the case like this, my lord. No,
I'm
I'm just,
asking you
I
a
am not a partner, but I've retired. I have placed before the authorities on earlier occasion, all documents possible.
Has there been a dissolution of the firm?
Yes, yes, there has been dissolution and reconstitution. The my other partners reconstituted themselves into a fresh.
Have you made that pleading?
Yes, my lord. That is my case. I have produced those documents itself. That is page under page. Lordship may peruse page 130, 114. This was extensively dealt. Page 114.
Partnership deed.
113 retirement deed to 114 reconstitution.
It is a notarized copy, it's not registered.
But liability of partners is joint and
That's what
several.
I have retired. The firm, they have accepted it. The bank accepted it. Tumkur Grain Merchants Association accepted the reconstitution. But this is, I do not want to say something background behind which it has been done. Anyway, these are things which is not on record. I can't please it. They are after him for no reason. Mandya DCC Bank, my lord.
Today, what the order is passed by learned single judge.
No, they dismissed the petition, but the show cause notice have to be stayed. My respectful submission, lordships.
They have not
But-
produced any certified copy of form number 1, my lords, where they say that they are no more a partner. We produced form number 1. It says he continues to be a partner, the latest one from the registrar of firms. They do not deny it. They have not filed a rejoinder to that. That is not even denied in their writ appeal.
Merely because there is a subsequent complaint by somebody else.
That's all. And no, lords,
My lords, it is
they are
not-
after him for, I'm very
15
reluctant to
crores
say this,
due.
but for political reasons. I mean, I did not want to say this. That are the instructions.
Whatever it is, but that.
No, but
15 crores is due, and
Nothing-
he admits,
not from,
he admits the default. He admits that he is in default in by way of an affidavit.
Nothing changes except the complainant.
complainant.
But 2022, my lords, he still continues
Learned
to be a
senior
defaulter.
advocate still. For the appellant. Notice returnable on.
The learned government advocate can take notice for respondent.
February 11. Learned additional advocate general Miss Mannapura accepts notice on behalf of one
That's R1, 2, my lords, R1 and 2.
respondent 1 and 2. The rest of the respondents will be served. For which
Please.
service by hand delivery.
By hand delivery.
Is permitted.
It's taking stay of the proceedings.
It is what stay?
Stay of the proceedings, no, he will go ahead, no. Show cause notice, he has fixed a date next week. They are in a mortal hurry to disqualify me, but lordships may suspend those proceedings until lordships hears the matter. Respondent number 2.
Since the contention of the petition appellant is that the second so cause notice is a gross abuse of process of law and would not to be received in eye of law. And that this court is to examine the said aspect, there shall be no further proceedings pursuant to second so cause notice by the authority concerned.
Date.
It is observed that on the next date of hearing, subject to convenience of the court, the appeal may be taken up for final consideration, looking to the compass of the controversy presently indicated.
Please.
Request for a date.
Date is 10/11, which 11th February.
Much obliged.
This is number 26. Mr. Ganpati Bhatt.
I am for the petitioner, my lord. This honorable court was issued notice to them. And my lord, they have taken time to file objection. Objection has not been received. Kindly see, my lord. Annexure
Let them file up.
A. Record here, my lord, is the question is, my lord, insofar as 2010, my lord, rejection order has not been served. After issuing the notification under section 27 of earlier act, old act, my lord, 28 has to be complied by within 30 days, my lord, that they have to comply. This is, my lord, your lordship has passed order under 23 amendment that is application is valid. Therefore, this is partially covered by your lordship's judgment. Therefore, my lord, if it is, my lord, that short date may be given, my lord, let them, because the 24 months by virtue of 23 act will be, my lord, completed.
Time to file reply affidavit is granted up to 5th February.
Please, my lord.
To be listed on 6th February.
Please.
Seal number 27.
My lord, if I can argue the matter straight away on the.
Like to appear for the petition in this case, my lord.
Which one? This one?
If I can argue the matter straight away on 6th.
Uh-huh.
Very well.
Okay, it is for you to file or not.
No,
Learned, AG has sought time to seeking instruction to file the reply, my lords. Let them file the reply and we'll make.
We'll recast the order. Learned additional government advocate, Ms. Nilofer Akbar, grace for time to consider filing of the.
Obliged, my lord, I am. Because that,
If the reply is to be filed, it may be filed before 5th of February. The appeal may be listed on 6th, petition may be listed on 6th of February.
obliged, my lord.
Okay.
So December 27, to check if the view.
Just logged out, we thought it was reserved. No, we thought we were ordering it.
Yes, Mr.
Lords, I beg to appear for the petitioner in this case, my lord. The Honorable Court has pleased to issue notice to the respondent and the learned AG has sought time to file the reply.
My lord, the prayer may be seen, my lord, the mandamus to consider the representation.
Yes,
Guru
my
Nath Vade.
That is all, that is the only.
My lords, there is an earlier order by this Honorable Court, my lords, which is at annexure B, my lords, wherein it was directed to consider the petitioner's representation within 8 weeks, my lord.
Earlier petition was filed, representation was directed, it was rejected again.
That has not been considered, my lords.
Earlier you
That
filed
is,
55118, in which the court directed to make representation.
Please.
Rejected, again you are here.
yes,
So it is a petition in repeat.
my lords, despite passage of more than 7 years, my lords, the respondent have failed to implement the court's direction, my lords. And there is no tangible development happened on the ground, my lord. Despite there is an administrative order sanctioning the amount of rupees 300 lakhs, my lords. I'm only seeking your lordship indulgence to direct the respondent to take immediate steps to maintain and repair the dam, my lord, which is very essential, crucial to the farmers, my lords. The damaged condition of the dam, my lords, poses imminent threat to the public safety and agricultural livelihoods in the in that region, my lord.
My lord, then I'll see that the representation is considered and I'll produce the endorsement, my lord. My lord may give me 3 weeks' time.
Just find out because earlier the
Very well.
learned additional government advocate, Ms. Nilofer Akbar, shall take instructions to apprise the court on the next date of hearing put upon 3rd of 5th of February.
Obliged.
December 28. To Ganpati Bhatt.
In this case, my lord, I am appearing for petitioner. Petition number, my lord, 1, 2, 3, my lord, 6 and 7. They have, my lord, complied the order which we have sought. And, my lord, insofar as petition 4 and 5 is concerned, my lord, during the pendency of this writ petition, my lord, which we have sought, my lord, prayer kindly be seen. Therefore, this is, my lord, prayer which we have sought is as against, my lord, government. That is respondent number 1 and 2. Directing to consider the report. This is 3E application, rule 3E application, new minerals found. After executing the quarry list, establishing quarry, my lord, in the scheduled property, new minerals found as per 3E application has been filed. All procedure has been followed. Thereafterwards, my lord, by virtue of an amendment, it is placed before the principal secretary of the government, Mines and Geology Department. And 5 cases has been considered. 2 cases, my lord, which is pending consideration before this court in the writ petition. 5 cases that they have passed order granting query lease. 2 cases, my lord, that they have rejected by the Mines and Geology Department during the pendency of writ petition, which is challenged in WP 35361 of 24. This may be clubbed because this pendency is relevant while deciding the matter. That is also pending consideration before this court. This writ petition may be connected to that, and my lord, once for all can be disposed of. That is my responsibility.
Which connected to which?
35361 of 24.
35.
361 of 24.
It was stated by learned advocate Mr. You are Ravindra Gajanan Kole. No. Bhat Ganapati Narayan.
Yes.
Writ petition number 35361 of 24 is connected petition, and that the present one is required to be heard together with the said petition. Accordingly, the present petition shall be listed along with writ petition number 35361 of 24.
Need it will be. That matter.
Listed on the day when the other petition is to be listed.
My lord.
To be placed on the day when the other petition is to be listed.
That is why we will move that matter before your lordship.
It's a fresh petition, my lord. It
Yes,
has-
yes,
It hasn't.
fresh
come before
petition,
my
fresh
lords as
petition.
yet.
To be listed with so and so, so and so. Both the petitions shall be listed on 5th of February, provided Office of Justice.
Much. Great.
Number 29. Ravindra Gajanan Pandit.
My lord, in this, there is something, Miss, my lord may grant me 2 weeks' time, my lord.
My submission, my lords. Way back on 30th July 2024.
Only objection is that you are granting more time.
My lord?
Only objection on part of the council is you are seeking more time.
No, my lord, I'm trying to resolve the issue.
No, I'm not on that, my lords.
For time you have no objection.
I'm not, the issue is, I may be granted the query list, my lords. That is my prayer. I'm not on the point of granting more time. Because now Rule 8.6 says, my lords, the matter should be placed before the District Task Force Committee, wherein the Deputy Commissioner himself is the chairman, and he himself has failed to comply Rule 8.5. I don't know under what circumstances defense could be set out by the learned government advocate. And for the last more than 6 months, time is taken. On 37, court was pleased
Lord,
to
I'm
pass an.
trying to resolve the issue, my lord.
Let them
Making
grant,
allegations
let
and,
them undertake that
attacking,
they
I
will
don't
grant the query
understand
list.
This
I have no
aggressive
objection.
attitude of these mineral advocates who appear for the mines matters. I'm attacked every time and I try to see that the matter is resolved.
So how long it will take now? 24 months are over.
I'll do it for you tomorrow, sir, because the deputy commissioner sits next to me.
Sir, you are also on the other side a few years back.
But such defenses I never put up, my lord.
They have all been a part of the government. They know the problems that I undergo. And today, tomorrow, I don't understand, my lord. I'm trying to resolve the issue.
What do you say?
I'm answerless for this submission, my lord. I may, a short time may be given in the first week of February. Let them
First week of
February, my lords.
6th of February.
Please, my lords.
As requested by learned additional government.
Number 30.
Lords, this matter pertains to the high security registration number plate.
Pardon?
High security registration number plate.
Learned Advocate General,
Let him come.
kindly have it on some other day, my lord.
When shall we give? This is to be sent back to learned single.
Please.
Yes, my lord.
Uh,
We are also agreeable to that.
Kindly have it.
Maintaining the interim order.
Yes, my lord.
2 weeks.
As far as the interim order is concerned, we have something to say, my lord, but I'll respond after the AG, my lord, makes his submission.
Let the advocate general.
Advocate General needs,
When shall we keep?
after 2 weeks, my lord.
Why? After 2 weeks? He's not here. Call like no difficulty after
available.
2 weeks. 30th January.
Sir, in 30.4, which is a PAL, can you make my submission, my lord? I have got a very small submission.
Together. Yes, next.
Grateful.
30th January.
Lord, interim order may be extended.
Interim order granted earlier shall continue to operate till the next.
In whichever matter interim order is there, in whichever matter the interim order is there, my lord.
Interim order, wherever operating, shall continue to operate.
December 31.
Please, my lord. Forest land
there was an order, my lords, in respect of forest land to divert that forest land without permission of the central government and allot that forest land to certain organizations. At page 34, my lords, is a copy of the order.
6-year-old matter.
Please.
7 years.
The state, my lords, has filed a counter practically admitting that it's forest land. The order impugned, my lords, is at page 34. Subject to reserve 78 acres out of totally 96.12 acres of government land in survey number 81 of Machohalli village, Dasnapura Hubli, Bangalore North Taluk, for public purpose and to grant the same for education and other purposes to private institutions on lease regarding.
40 years then is forest land.
Lord,
My
they
lord,
have,
the learned advocate general will be appearing in this matter, my lord. My lord may have some.
Lord, may I just point to their affidavit? Two affidavits, in both they have taken a categorical position that this is forest land. They don't dispute it at all.
My lord, one of the petitioners is dead, the petitioner number 1.
Lord, I have filed a memo. Petitioner number 2, my lords, is alive.
PIL. This is PIL.
Please, my lords. And one petitioner is still alive. On 19/8/2019, my lords, the state.
You are for?
I, my lord, appear for Mr. Ravi, my lord, we appear for some of the respondents, my lord, to whom the lands have been, my lord, allotted, my lord.
Yes.
Lords. Your lordship may please, my lords.
Oh, this was considered earlier.
My lord, this was heard for some time and then,
recollect.
yes.
Lords, then may I show, my lords, the original notification, which is in the writ petition, under which this land was declared to be forest land. That your lordship will please find at annexure B, page 51.
Mysore government.
Government,
My lord,
see, there are acres and acres of lands in state of Karnataka which are declared as forest land by your forest department.
yes, my lord.
But your revenue department goes on allotting the same to so many other persons, private individuals. State has to resolve this. I think Mr. Valla also will have encountered it when he was the Advocate General. I mean, there are thousands of acres, sir, with our limited thing what we have come across. Where forest department says it is forest land,
Yes, the revenue department.
the revenue department keeps on allotting it to XYZ persons, considering it a Gomal land.
Yes.
Now, how do you resolve it? You have to come up with a mechanism.
This all has been occurring because of that Mysore government notification.
Please, my lords. Yeah, that's the notification, my lords.
This is a plantation, not even a forest land, but I'll point out, let me complete it, because this is a plantation land, not, my lord, a forest land. I'll point out. And what's the effect
No,
of?
but even then this issue is there, is alive, what I said just now.
Of course, there's always a tussle between the forest department and the revenue department. That's been, my lord, constant been, my lord, that we find. Where either this side or that side, my lord, we find this.
My lord, on some other day, my lord, the learned advocate general be appearing in the matter.
Very. Tell the date.
And my lord may fix a date and I'll intimate
11th February.
11th.
Please.
Please.
Number 35, Mr. GM Nataraj. 35.
We have complied.
We listed at 230 on 20. Complied with
Complied. 35.
on 23rd.
Filed our affidavit also. That's with, we have filed our affidavit also, Minos.
Number 36. Prashant.
Here again, we have filed our compliance affidavit, Minos.
Disputed, my lords. The land is a grant land, my lords, for the ex-army men, my lords. They say that, my lords, I'm in possession of survey number 102. The grant made is in 101, my lords. The present RTC states that, my lords, the RTC in my name for 10 acres and rest has been allotted to the forest land, my lords.
It is notified as a
no,
reserved
my lords.
forest, my lords.
They say that it is-
Kodi and Durasti cannot be conducted in the notified forest land, my lords.
As notified in the year 1915, my lords. They say that based on the notification of 1915, my lords, the land has been, my lords, transferred in the year 2010. Rest of the land which has been allotted, my lords, apart from me, my lords, one more person has been allotted this land, my
The
lords.
direction of the Honorable Court, my lords, is to consider their representation in accordance with law based on the missing records, committee records, my lords.
So file some compliance every.
Yes, my lords, we have filed
My lords, one
lords,
kind submission, my lords. My lords,
paragraph.
my lords, one kind submission, my lords. The annexure R1, my lords, in the compliance affidavit, my lords. Annexure, may I read, my lords? May I read, my lords? Annexure R1, page 7, my lords. They say that, my lords, in the meeting that was held on 25/10/24, in relation to the preparing of the missing, the file in respect of the land 101 of Kadaganahalli village, Kasba Hobli, granted to Kalappa by order of the special commissioner Hassan so and so and so. Since the deputy conservator of forests informed that the land belonged to the Kanchana Kumari Reserve Forest, upon verification of the concerned notification, in the said notification, survey numbers are not mentioned. There is no mention of survey numbers with respect to the notification, my lords, but only boundaries are mentioned. Therefore, the technical assistant to the deputy commissioner and ex officio deputy director of land records, Hassan, was notified to personally verify whether the said boundaries include the lands in survey number 101, 102 and submit a report along with the sketch and documents. They say that accordingly, technical assistant to the deputy commissioner and ex officio deputy director of land records has submitted a report on 26/11/24 and informed that the land granted to Kalappa is in survey number 101, but has been in possession and enjoyment of survey number 102. As per the government notification that is dated 14/4/1915, my lords, both the said survey numbers belong to the reserve forest area as per the so and so and so, my lords, Adhiniyam 1980. There is no scope for doing any kind of non-forest activities, my lords.
The next paragraph,
RTC,
my lord.
my lords, RTC,
Next
my lords.
paragraph is important, my lords, in the same. The above points are discussed in the meaning. Since these said survey numbers belong to the reserve forest area, it is decided and resolved that it is not possible to conduct durasti and give new survey number by preparing missing file, and accordingly the Tashildar Sakleshpur is directed to issue suitable endorsement to the applicant and with my lord.
Lords, survey number 10, my lords, 102. My lords,
We are closing it. Heard learned advocate Mr. Prashant.
please, my lords.
EN for the complainant and learned additional Government Advocate Srimati Pramodini Kishan for the response.
Permitted to challenge, my lords, if that is the case, my lords,
Learned-
before
for learned
the.
single judge in the writ petition, the prayer of the petitioner was to direct the authorities to consider the representations regarding preparing of missing records and to conduct Podi and Durasti in respect of subject matter land. Full stop. The petition was disposed of by learned single judge as per order dated 2nd November 23, whereby it was directed to responder to Deputy Commissioner to consider the representation of the petitioner dated 28/3/2019. Full stop. When the contempt of court was alleged in respect of the above direction by filing this petition, the authorities have responded with affidavit reply in which, along with which endorsement dated 29/11/24 is produced, wherein it is inter alia stated that the land survey number 101 at Kada Garahalli village, Kasba Hubdi, Public Sakleshpura, Taluka, is a reserved forest area. And non-forest activities cannot be undertaken therein. It is therefore stated that it is not possible to conduct Durast and give new survey number. Also, the request of the petitioner is thus rejected. Paragraph. The said endorsement is based on the proceedings of the missing files committee, meeting of which was held on 29/11/24. Full stop. Since the direction of learned single judge was only to consider the representation of the same has been considered and the decision is rendered. In that view, the contempt cannot be alleged. The direction is complied with. Nothing survives in the present petition. It is accordingly disposed of.
I may be permitted, my lords, to challenge the endorsement before the lower court, my lords.
Learned
I'm in possession of the land for more than 40 years, my lord.
Learned advocate for the petitioner at this stage submits that petitioner may be permitted to challenge the endorsement, aforesaid endorsement on merits. Such liberty is reserved. However, this court does not express anything on merits.
Grateful, my lords.
About such recourse. Next.
Number 38, RB Sadashappa.
37.
Number 37.
My lords, in this matter, I pray for 2 weeks' time, my lords. This matter, my lords, I pray for 2 weeks' time.
2 weeks' time.
Please, my lords, the difficulty is, my lords, the pursuant to the engineer's report.
6th February.
Please.
Number 38, Venkatesh TS.
Appearing for the petitioners, my lords. My lords, the matter pertains to new pension scheme and old pension scheme, my lords. My lords, there was direction from the single judge to consider my representation, my lords. It's been almost 7 months now. They've come on an appeal, my lords.
University has filed appeal and it is listed today, my lords. It may be tagged up and taken together.
It is listed today.
Please, my lords.
Please, my
Serial
lords.
number 59, my lords.
To be listed with writ appeal number.
So there are 3 petitions, my lords.
For the time being, keep back. If doesn't reach, then to be listed with writ appeal number.
My lords,
Serial
serial number 1079 of 24, 1084, my lords.
1079 of 2020.
1084 of
Wait, if it
2020.
reaches, then will otherwise to be listed on the day. Next.
My lords, serial number 38, 39 and 47 arise out of the same.
All.
38, 39 and 47, my
All
lords.
may be kept back for pass over for some time. Yes. 41.
47, my lords.
Yes. Now.
Number 40.
Obliged.
The
40
case to
No, 40 is same. Now 41.
40.
40 is different.
40 is different all day.
Number 40. Mr. Keshav Murthy.
47 is. Yes.
Number 40, Mr. Keshav Murthy B.
4th February. 4th February.
So number 41, Mr. S. Srinivas Gowda.
For the complaint, that the land is acquired
1 week time.
at the last 3 occasions, Mulad, the very same submission is making, Mulad. Let the SLV may be directed to present, Mulad. Because land is acquired, Mulad, the order of the learned single is to pay the compensation, Mulad. Page number 35, my lords.
KIADB is condemned.
KIDB, my lords. I am for the
Therefore, KIADB.
And 1 week time.
deliberately not complying the order. 3 occasions, the same stage it is listed. my lord.
So which are the direction?
Let's
Where are the direction?
land acquisition officer.
Where are the direction?
Let's page number 35, let's.
Read it.
Yes, in view of the fact that compensation under consent award is considerably higher and the denial of same to the petitioner and respondent number 4 on ground of dispute which are settled would not be appropriate. Therefore, general award dated 5/7/2021 at annexure Q stands quashed insofar as land bearing survey number 481 measuring 2 acres 12 guntas of Maralwadi village. Respondent number 2 to consider petitioner's case for passing of consent award and thereafter SLEO shall take note of compromise for disposal of amount. Time limit for taking above steps shall be 2 months from the date of receipt of copy of this order. Copy is also served on them on January 24th, 2024.
Only 1 week. time.
3rd February. As requested by law and respondent. Yes.
42, 43 are urgent. Seal number 44.
That's,
So Prasad K.R. Rao, 44.
Here also we have filed our compliance.
23rd at 2:30.
Urgent. Seal number 46.
Appear for respondent number 3.
Compliance affidavit is not served on us, my lords.
We filed. I'll serve it.
We'll make our submissions in the next date of hearing, my lords. Pray for time, my lords.
So, madam, you are appearing for
46.
46 respondent number 3, my lords.
43, 46.
46 respondent number 3.
Like, what is the matter?
Lords, in this matter, my lords, 46, writ appeal has been filed, my lords. Writ appeal number 55 of 2024 is filed by respondent number 2, Coir Corporation.
Copy of the complaints is not served on. Copy of the complaints memo not served on me.
Here for the government, my lords, Coir Corporation, respondent number 2 is represented by another counsel, who's the competent authority. But instructions are writ appeal has been filed in 55 of 2024 by respondent number 2, my lords.
When it is coming up?
What's that? Respondent number 2 is online. They have to submit because it
Who
is
has
their
filed writ appeal? Who has, you have filed?
respondent
And
number
the
2.
complainant is not.
Which respondent has filed writ appeal?
My lords, we have filed writ appeal 55, my lords, for 24, and it is pending for consideration, my lords.
When it is coming up?
My lords, I'll
Date is given or not given?
Date is not given, my lords.
Not given, to be listed with writ appeal number 55 of 24 on 4th of February.
And they may be directed to serve the copy on me, my lord, with the complaints memo, what they have said. It's not served on me
By the appellant.
respondents.
We'll serve it, my lords.
You are filing compliance memo?
Lords, we have not filed minutes. Only writ appeal I.
So, madam, you serve the
It has
copy
to
of the
issue the
appeal to the council.
Complaints to be done by the BBM.
Yes, my lords, we'll serve them.
Yes.
Copy, my lords.
Yes.
Hello. So 47 pass over, 48. So Radhanandan BS. Oh, I'm sorry. Sorry, ma'am.
47, same order as 41.
Complaints have been filed, my lords.
48. I'm sorry. I should not have represented the previous matters. I thought 48 is called.
48.
I'll make my submissions after that.
Lords, complaints has been filed, my lords. The khata had to be issued, my lords.
Thought I should have.
Khata had to be issued. It will be issued. E-khata will be issued. It's in progress. Lords, the e-khata is in progress, my lords. It will be issued to the complainant, my lords.
Will we record your statement?
Please.
Within which, what time?
4 weeks, my lords.
Then
No,
we'll
no, because the e-khata is in progress.
When will dispose of?
Please.
If he undertakes that, he will issue it.
We are recording the statement.
Time limit may be kindly. Because there cannot be one more.
The directions of learned single judge which are brought under the
And it
contempt
be-
jurisdiction.
Date may be
in
fixed
paragraph
for
12 of
production.
the order dated 13th February 24, reading as under, then what paragraph 12. Paragraph. Learned advocate, it is the grievance raised on behalf of the petitioner by learned advocate for learned advocate Mr. So and so that e-khata is not issued, though directed by learned single judge. Responding to the above submission, learned advocate Mr. So and so for respond number 2.
Yes, my lords.
2 stated that the process of issuing e-khata is in progress and the e-khata to the petitioner hearing shall be issued within 8 weeks from today.
Hello.
Full stop.
Great.
Relying on the said statement, the contempt proceedings are dropped at this stage. Full stop. If the order is not complied with, the respondent concerns will be exposed to the aggravated form of contempt.
Hello.
Great.
Time limit. Time limit.
8 weeks.
Hello. Number 49. To Keshav Murthy B. Number 49.
49, 5th of February.
Number 50 say. Keshav Murthy.
Same, 5th of February.
Number 51. Mr. Prakash. Number 51. Mr. Prakash.
For the complaint. Senior is on it.
My lord, may I just appraise the court of the facts in this, my lord?
It is not the compliance what the respondent National Highway, though has filed the complaints affidavit. But the issue is simple that if a compensation assessed could be paid belatedly, whether the land losers are entitled to get interest upon the said compensation or not. Lord, the learned single judge, though has passed a specific order and
In this case, what has happened is that
I will
under
explain.
a supplementary award, I was required to, if I did not disburse compensation within a period of 4 weeks, I was required to pay 18% interest. Then I sought extension of time for 4 weeks to verify the beneficiaries. The learned single judge was pleased to grant me that extension of time. And while granting that extension of time, he clarified that if there was any condition regarding payment of interest in a previous round of litigation, then that condition would continue. But as far as this particular matter out of which this contempt proceeding arises, my lord, The interest requirement was only if I failed to comply within 4 weeks' time. I sought an extension of a further period of 4 weeks. I was granted that extension subject to deposit of the entire money. Once I completed the verification process within the additional period of 4 weeks, I withdrew that money and disbursed the compensation. There were 2 original orders, my lord, one of which stated that 18% interest had to be awarded. So in that second round of proceedings, the operative portion of that order is at page 22. In that second round of proceedings, my lord, I paid compensation with 18% interest. But in writ petition number 31457 of 2017, there was no direction regarding the payment of interest. So when the petitioners in the present case, my lord, had filed an earlier round of contempt proceedings, I filed an affidavit clarifying to the Honorable Division Bench that I was only required to pay interest in writ petition 21476 and not in writ petition number 31457. The Honorable Division Bench took note of my submission and passed an order disposing of that contempt as the order having been complied with. Now they filed a separate contempt petition, my lord, contending that I ought to have paid 18% interest for the remaining beneficiaries as well. The petitioners in writ petition number 31457. So I have placed on record an affidavit of the party, my lord, explaining in detail, narrating all the entire sequence of events and showing how my compliance has already been taken note of by the contempt court on a previous occasion. I've also produced that contempt order, my lord, as at page number 59, along with my affidavit.
Lord, without even allowing me to commence my submission as to how I am justified in filing this contempt.
Today you have complied with or not?
I'm fully in compliance with the order, my lord. The affidavit is on record. I filed an affidavit. The affidavit is filed on 3/12/2024. I filed an affidavit with all the supporting documents, my lord. The payment details are at page 54-55, my lord, showing disbursement of compensation to all the beneficiaries.
Paid interest also.
My lord, interest, my lord would see there are three orders, my lord. One is writ petition number
They are
3.
concerned with only last order.
The last order, my
Yes,
lord, the 18%.
Lord, I
interest.
think my learned friend allow me to make my submission, but I will make out what my case is. Lord, the issue arose way back in 2017, wherein all the complainants and other 8 persons are the land losers, the residential properties. Lord, along the side of National Highway proposed, 275 Bangalore-Mysore Highway, these properties were notified for acquisition. And after a notification, the process, Lord, in the month of March 2017, award was passed, determining the compensation. Well, within no short period, the land special LAO has realized there are certain mistakes. Then he has communicated to the accused to return the original award. Accordingly, it was returned. Thereafterwards, my lord, he has passed a supplementary award and instructed the accused to pay the difference amount of 7,52 lakhs. But so far as this proposal is concerned, Lord, the accused has sent a communication disowning to accept this. So this was the cause of action. Lord, Annexure A is the communication made by the accused to the special land acquisition officer disowning it. Lord, this has gives rise to a cause of action for filing a writ petition at an earlier occasion with 31457 of 2017 challenging this communication and a direction to the accused to make good the compensation under the supplementary award. The learned single judge allowed the writ petition, the communication was quashed and a direction was issued. And this was subjected to challenge by the accused before the before the division bench. Division bench has dismissed it and confirmed the order passed by the learned single judge. Review petition was filed. Lord, during that course, Lord, 8 persons who could not able to join hands with the previous writ petition, Lord, they come up with a prayer to accord, the same relief with that of the earlier one. I would like to draw my lord's kind attention to page 41, please. Page 41. The prayer sought is issue writ in the nature of mandamus to the respondents to disburse the compensation in favor of the petitioners as per the supplementary award dated so and so, order dated 19/7/21 in WP 31457 of 2017, wide annexure so and so. Lord, the learned single judge in that writ petition has passed this order at page 43. A mandamus is issued directing the respondents to disburse the compensation amount to the petitioners as per the supplementary award so by direction E within a period of 4 weeks from the date of receipt of the certified copy of this order, failing which the interest as awarded shall stand enhanced to 18%. But this order is also subjected for challenge before the division bench. They suffered. Review petition filed, they suffered. But thereafterwards, immediately they have not pursued the matter before the apex court. They kept quiet. But taking note of this order, the latest one, but a contempt petition was filed by the first petitioner in 214476 of 2021. But when the matter was listed before the this honorable court and having caused notice, more than a couple of occasions, they have taken the time by pleading that they are about to file a SLP before the apex court. But even before filing the SLP, they have filed a writ challenging the supplementary award which was tested judicially before this honorable court before the large single judge and confirmed by the division bench.
What happened in leave petition?
It dismissed, my lord. SLP dismissed. My lord, before filing the special leave petition, the latest writ petition was filed by the accused, my lord, without making none of the beneficiaries as the parties, at whose instance these two orders were passed. And this factum was brought to the notice of the Honorable Apex Court and imposing heavy cost was, proposed. And however, it was, dispensed. So far as the first challenge is concerned, it was dismissed. And looking into the consequence of the first challenge, the second
Compensation is paid or not?
compensation only is paid. But this is what exactly, my lord, the second set of writ petitioners, 8%, with 18% they have paid. So far as the first writ petition is concerned,
Parties through their respective learned advocates are directed to place on record the calculation of the figures of compensation paid to the petitioner.
it is filed along with the statement of objection. My lord, currently for a couple of minutes, I will take my lord's attention to that.
Permit me to
Please,
clarify.
please,
madam.
please,
My
madam.
lord,
I am on my submission, please, madam.
May I just be permitted to make two submissions, madam?
No.
The present contempt petition, if my lord would see the prayer, it says they're accusing me of contempt of two court orders. One is the order dated 6/3/2024 and the other is the order dated 4/6/2024.
What's the amount you have paid?
My lord,
What amount you have paid?
I have paid the entire 7 crores. My lord would just see at page 54 and 55. I have produced all the figures, my lord. I have 54 and 55. If my lord would see column number 8, it is the amount of LA compensation that has been paid.
And column number 9.
And column number 9 is 18% interest. I have paid 18% interest to all the petitioners, my lord, in writ petition number 21476 of
Irony
2021.
is under the same notification, same set of land losers.
Attempting in
And
contempt proceedings to obtain.
at least allow me to make my submission, madam. I am in the midst of my submission. The 00 which figures for all the petitioners in the earlier one and the payment of interest wherever made in favor of 8% who have taken advantage of the first order. And now my learned friend is trying to dissociate between these two. The the land losers among the same notification for the same purpose, despite a specific direction and clarificatory order given by the learned single judge. So that's why I would like to take my lord's attention to the recent order passed by the learned single judge in which the challenge made by the accused was dismissed with an observation. Let me take my lord's attention to page 59, please.
You got the amount of 7 crores 52 lakhs.
My lord, principal amount is paid, not the interest.
Okay.
Not the interest.
Just
How come they deny it? Even it is statutory under section 80 of the
The petitioner
2013 Act.
was attempting to obtain a decree at the hands of this court. The order directing payment of interest, my lord, is not available on the record. I may just be permitted to point out to 3 orders, my lord. If my lord would see at page 35 of my compliance affidavit, page 35 of my compliance affidavit, my lord, is the operative portion of the order dated 6/3/2024, which I am accused to be.
Then what is your stand about interest?
My lord, as far as whatever the court orders are with regard to interest, I have complied with in full.
This is also false.
The court's orders have complied. My lord would only see at page 35.
Calculation.
My lord,
Give the calculation.
I will do that. I'll make the
Amount of compensation. The tune of 7,52,08,593 is already paid to the petitioner. Therefore, that part of the
May I just make one submission, my lord?
substantial part of the order is complied with. The dispute appears to be surviving is about the payment of interest at the rate of 18% as contemplated in the order dated 6th March 24, brought under the contempt. Also, in this regard, paragraph, learned advocate for the respondent is so and so shall place on the record the amount of interest paid, if any, before the next date, put upon 6th of February.
Obvious.
Office objection only.
Number 52. AJ Srinivasan. 52.
Nobody is there.
A complaints affidavit has been filed in this matter. Complaints affidavit has been filed.
23rd at 2:30. 53 appeal. Let it go to 12th February.
53.
Lords, the UGC council is served, my lords, he is representing. So therefore, the compliances is done. If my lords could give us a date, my lords, there is some urgency in the matter. This was that last Friday matter. The only compliance left about was with regard to serving of the UGC council. Last date, we have taken notice on HR Shauri, my lords, he is represented. So notice is complete. If it could be taken up in the hearing matters, regular writ appeal matters, my lords.
Put up, when do you want? Now there is no time.
I get it, my lords. That's why I am guarded. My lords, next Wednesday or something, there is some urgency.
What is it about?
My lords, matter relates to recruitment, my lords, to the post of guest faculty and guest lecturers, my lords. State government, we are short of 1,600 guest lecturers. Counseling is scheduled for Monday. And thereafter, my lords, subsequent developments we can place before the court. If there is shortage, I can get an order from
7th February.
7th, please.
May I make? My lord, the writ appeal itself is not maintainable for a simple reason. My learned friend, the state government has challenged the order, final order passed by the learned single judge, wherein it has specifically said the state government should follow the UGC guidelines so far as qualification is concerned, and only those candidates who have got qualification should be appointed. Then, my lord, after passing of the order on 5/9/2024, my lord, immediately, my lord, on 10th, my lord, they have issued a notification, including those unqualified candidates also. Then an application was filed, bringing it to notice of the court, and this, the learned single judge, moved the learned single judge has passed an order saying that, and before the learned single judge, I sought for stay of that selection. Before the learned single judge, the additional government advocate has given an undertaking saying that they would follow the final orders. They would appoint only the qualified teachers. Having said so, my lord, that is not challenged here. My lord, I am wanted to file, my lord, this, that the order passed on IA after disposal has not been brought to the notice of this honorable court. Take this.
Next day we'll consider.
My lords, one
No,
request.
appeal
Can
itself, my lord, is not mental because having undertaken, my lord, saying
That's
that
the
we
only
obey the
difficulty.
order, directions issued by the
The
court.
difficulty is this, we will be short of, my lords, 10,600 my lords, guest faculty have to be recruited. Now, my lords, in case we are following the UGC regulations, in terms of the single judge's order, we have notified a counseling. Even after the counseling is over, as per our statistics, we'll be short of the shortfall, my lords. Then UGC, then, my lords, this honorable court could permit us to, my lord, to fill up with the other persons. So their priority, their grievance is addressed. So therefore, my lords, again, only request is, my lords, 20th counseling is scheduled. If it could be taken up on 23rd, my lords, it's a short matter. Only on that.
Not
matter it
afterwards,
could
my
be
lord,
disposed.
because we do not know.
23rd, my
It will
lords.
come, my lord, on first week of February.